Good evening, everybody, and welcome to today's episode of Marvelous Medicine. Though the title says Law, What the Doctor Must Know, it's actually for all medical personnel. I had some queries from nursing staff. Marvelous Medicine is open to all, including lay public. We've never had any restrictions for anyone who was interested in any topic. And though we primarily aim this session at doctors, we are very happy to welcome everyone today. The speaker is Dr. Satvik Pai. He's a consultant orthopedic surgeon at PES University Institute of Medical Sciences and Research, Bangalore. And he's also the managing partner and lead medico-legal consultant at Guardian Med Legal Consulting at Bangalore. Satvik did his MBBS from St. John's Medical College, Bangalore, and MS Orthopedics from Ramchandra Medical College and Research Institute, Chennai. He went on to do his postgraduate diploma in medical law and ethics from National Law School, Bangalore. He's also done certificate courses on basic legal issues in medical practice and on medical error case studies from the Stanford University. As far as orthopedics is concerned, he has several fellowships in arthroplasty, arthroscopy, and sports medicine and trauma. Satvik has over 35 publications to his credit, and he has been, he has delivered several guest lectures. I met Satvik at Mangalore at Kim's, and where he was a guest lecturer, and the title was "A Tryst with Law: Walking the Legal Road in Medicine," and it had such a huge impact on me that from that time I decided I have to somehow, by hook or crook, get him to come and speak on Marvelous Medicine. So it's been almost a year, and then it's now finally happened. Moderating the session will be Dr. A.L. Meenakshi Sundaram, who's an anesthetist by profession. He did his MBBS from Tanjore Medical College, diploma anesthesia from Madras Medical College, and MD again from Tanjore Medical College. He was the Director of Medical Education and Research, Tamil Nadu, for a while. Before that, he was a dean in several medical colleges. He has been the president of Indian Society of Anesthesia, Tamil Nadu. He's been awarded the Best Doctor Award by the government of Tamil Nadu, Best Teacher Award by MGR Medical University, and he was recognized as a Tamil Semmal by government of Tamil Nadu. He's very much interested in poetry, and he's released 11 books in poetry. And my friend Patsardi, who put me in touch with Dr. Meenakshi Sundaram, says he's the ultimate authority on Kannadasan's lyrics. So maybe towards the end, we'll have some interesting discussion about Kannadasan's lyrics. Last but not the least, the real authority for today is Justice Kannan Krishnamurthy. He's the founder of Madhyastham, which aims to popularize, train, and practice mediation rather than litigation. Justice Kannan did his bachelor's in economics from Loyola College, Chennai, and then graduated law from Government Law College at Pondicherry. He's a former judge of the Madras High Court and the Punjab and Haryana High Court, and he was also the chairperson of the National Railway Claims Tribunal's Principal Bench. He believes that unless you actually write books about law, you haven't done justice. So as he was mentioning earlier, he's been very much involved in legal publications, especially medical legal aspects. So today I have informed all the previous audience before that you can throw any question and we have people to answer it. So we hope to have a very interactive session. But for beginning, we'll just allow Satvik to just bring us up to date. Over to you, Satvik.
Thank you, ma'am. Thank you. So we'll get started.
So just so you know, Satvik, we have over 85 participants logged in.
Great. Yeah. So my screen's visible and I'm audible?
Yes, Satvik. Clear.
Okay. So first of all, I'd like to thank Dr. Vidya. She's been very kind to have me for this event that's been running for so long, so many episodes that I was just following up on what they've done, and there's so many good topics, so many things they've done. And Dr. Sundaram as well to be here to moderate the session for us. And obviously, Justice Kannan, absolute honor to be even be in his presence and be able to speak anything related to law in his presence and with all his authority in this field. So basically what we are going to be talking today is about certain legal aspects that all doctors must know. Now this, if you see the title, it's not all legal aspects that doctors must know, because it's not really possible to cover everything that, we should be aware of within a short period of time. And I'm going to keep this talk reasonably short, not to go, make it too much of a sermon and then, people lose interest, all of that. And I'm also going to try to keep this talk as relatable to the medical field. So the point is not to, use a lot of legal jargon, all of those things. Law in itself is quite complicated. It's quite precise in many matters. So in some ways, it's a little bit hard to simplify. Takes a lot of time to understand also, but I'm going to try to simplify it, because at the end of the day, the point is that the doctor should know what it is. The doctor should be able to understand what it is. So only if they understand the law, only if they know these aspects, can they then go ahead and make changes in their own practice, right? So the talk's going to be on that. So already Dr. Vidya has given a great introduction for me, so I'll skip about myself. So the first question I'm sure a lot of doctors have in their mind is, why bother? That's the most, when I interact with people now, at least we have 70, 80 people here who are interested. That's the first step. They've taken that initiative, but I'm sure there's a lot more. And even among them, there's that lingering doubt in their mind as to why bother, why we have so many things in medicine that we are studying our practice. So why bother about the law specifically? It's something that lawyers will deal with. So in this initial part of the talk, I'm going to first try and convince you on why you should be bothered, and then going to get into what you should actually be bothered about. Okay. So this is a quote which says, no physician, however conscientious or careful, can tell what day or hour he may not be the object of some undeserved attack, malicious accusation, blackmail, or suit for damages, right? So this sounds like something that we just give me a second. Yeah, so this sounds like something that happening nowadays. Last 10 years, you hear a lot about it in the media, all of this conflict between the public and doctors. So, but what this quote was actually published in the Journal of American Medical Association in 1892. In 1892. So all those decades ago was when this quote was published. So there is some inherent conflict between medicine and law. Okay. So that's something that we need to understand, and we need to understand how this relationship works. Now, coming to the current situation. So this was a study published in the US. So in 2021, among the doctors that were surveyed, more than 50% had at least one lawsuit. That means every second doctor that you spoke to in the US had at least one lawsuit against them. And when it comes to surgical fields, that number was even higher. It was more than 80% among the surgical fields. Now, in India, unfortunately, we don't have such data. We don't have exact data on what is the incident and all of it, but it's definitely increasing. It is definitely increasing. So whenever I speak to doctors who are a little bit older, not to say that they are aged, but who are a little bit older. So what they tell me is, they've practiced law from so long, and how they have practiced medicine from so long, and medicine has changed in India recently. So they say medicine is right now at its crossroads, between what it was before versus now. So I would like to just dispel their belief that it is at its crossroads. So it is very well not at its crossroads. We are definitely on the highway to hell. Considering the amount of litigation, it is increasing by 110% every year. So in the consumer courts, 12% of the entire cases for all specialties, all fields, more than 12% is medical legal cases. So that's the amount of cases that are there, medical legal, and the rate at which it's increasing. So we are not at the crossroads. We are not at some point where we decide how the future is. We are definitely on the highway to hell, and there's only one way it's going to go, which is going to keep increasing. So now, why what are we doing that this situation we are in, and in the direction that we are going to? So there's certain causes for this increased litigation, right? So one is the increased number of patients. The more patients you see, inevitably there is some complications inevitable, and that would at some point likely to end up in litigation. Increased access to legal services. Again, that's a good thing. Patients have more access to legal services. Patients have an increased awareness about their consumer rights. Increased educational status among patients means increased educational awareness about these things. They can access lawyers. Increased litigation. Increase in healthcare costs, something very specific to India. So in India, you will find that patients, whenever they complain of something, their first, there may be a ton of reasons that they give, this thing didn't work, all of it. but eventually you will hear one line, I paid so much and still this happened. So no matter what you do, cost is definitely a factor in India. And once costs increase, the patient's expectations in general increase. Then there is an increased commercialization. We can't deny that, increased corporates, there's more demand on doctors to show numbers. All of these such practices end up creeping up into our practice, and that is also an increased reason for increased litigation. And then there's the deficiency in effective communication. So if you see all of these points, right? So how much can we really do or change why I say that we can't really change our path is that if you see all of these points, other than effective communication, all of the other points are basically out of the hands of doctors. So it's not really that, okay, individually, you definitely have to have very good communication. But even if you do, even if you take all of the precautions and have really good communications with patients, it may not be in your hands as to facing litigation. Okay, and the last point is the legal standing favoring consumer rights. So in general, the law will favor consumer rights because it would see them as the victim. So the law is reasonable at all points, but in general, it would favor a victim in general. Okay, so now coming to why now. So another question that I get from doctors is, why should I bother about this now? If there's a case, I will think about it when a case comes. Why should I break my head about something which has not even happened? So I'll just give you an analogy. So if you are going into a war zone, right? If you are going into a war zone, you know that you need to protect yourself with a bulletproof jacket. When do you think you need to wear that bulletproof jacket? Before you enter into the battlefield, or after you are facing head on with your opponent, that opponent's pointing a gun at you, and are you then going to wear your bulletproof jacket, or are you going to get into the battlefield with that bulletproof jacket? So being aware of these points is like your bulletproof jacket, and the point is to have that on before you enter into the field, not after you have a problem, after the patient then is threatening to sue you or has filed a case, and then you trying to know, that's already too late. So the point is to have all of this information before you face such a problem. Another question that I get is, should individual doctors, they ask, should I bother? These most of the cases are for these senior doctors who have who see so many patients a day. Relatively question that I very often get from junior doctors, should I really be worried about all of these points? I know I barely see these many patients, I don't see high profile patients, all of that. So then I'll give you another analogy. So if you are going scuba diving, right? Say you've gone on a holiday, you're going to go scuba diving. In this picture, there's this expert and there's this person who's clearly a novice who's just gone scuba diving. Who do you think requires this oxygen support more? Is it the scuba diver, or is it this novice? So you saying that no, it's these experienced people who already have cases, they are the ones who need to be worried. They have been facing it from some time. They know all of these aspects. So they have been doing it. They are capable of surviving to some extent without this oxygen. But if you are a novice, then it's even more important for you. So and another point is, who do you think is more likely to make a mistake? Someone who's experienced or someone who's new? So it's always the new person who's likely to end up making a mistake. So it's them for whom all of this is more important. All of it is more important to be aware of, right? So now I'm going to get into what we need to be aware of. So how I'm going to do this is I'm going to just talk about 11 real life case scenarios. So all of these are cases that we have had, that people have approached us with, or even if it has not ended up in lawsuits, these are issues that I have seen firsthand or heard from a friend that have happened in the hospital, right? So I'm not going to talk detailedly about some legal case or something like that. I am going to talk about real life case scenarios that you face in the hospital and how you deal with them. So I'm going to try and keep this interactive so that we get the opinions of all the doctors as well, to understand how they are thinking, and then basically get some inputs on what would be the ideal thing to be done in such situations. So I'll give you the first case scenario. So there's a neurosurgeon operating a brain aneurysm. Okay, right? It's a complicated surgery he's doing. It's a small aneurysm. He's operating that aneurysm. While operating, the aneurysm ruptures. Unfortunately, as a result of that, the patient is paralyzed. It's all a matter of millimeters, small aneurysm. Inevitably, despite his care, the aneurysm ruptures, and now the patient is paralyzed. So now, first question is, whose mistake is it? So inevitably, it's in the surgeon's hand. So it's the surgeon's mistake. Now that is understood. It is the surgeon's mistake. I mean, ideally that shouldn't have happened. Even he knows that he shouldn't have ruptured it. His entire aim was not to rupture that aneurysm. He knows that that's the complication. He knows what's the consequence of that complication. And still, maybe a twitch this way, a twitch that way, and the aneurysm is ruptured. So now what? So now we have established that this has been caused by the surgeon. It is his mistake. Is this medical negligence? So the question is open to everyone. So from the audience, I would like to hear from anyone, what they think is the situation. Now, the patient, just try and think of this from the patient's point of view. They've gone in, they've trusted this surgeon. He has made a mistake. As a result of that mistake, now he may say it's a small mistake, but as a result of that mistake, the patient's is paralyzed. He can't walk, he can't move his hands, and he's paralyzed for life. So he has to deal with life for so long. And he's saying that the surgeon is at fault. So now what do you think should happen ahead? Forget what the law states. Just by general the humanity, what do you think should happen ahead? Questions open to anyone. There's no right or wrong answers. I just want a perspective on what they would think would happen. Anyone can unmute and just speak. No problem. Just
Yeah,
unmute.
this cannot be considered as a medico-legal negligence
Okay.
because it is negligent only when the doctor, that is, when he is not aware of the thing. You get my point. That is, a equally competent doctor, uh, he also will be able to make this mistake. This is one of the complications. So while obtaining consent, it should be clearly explained that this is a complication and there is chances for it to occur. Then it wouldn't have been a problem for him.
Okay. So anyone else?
If I can answer,
Yeah.
I think if legally, the onus is on the plaintiff or to prove negligence. The lawyers for the plaintiff will have to show that the neurosurgeon did something that didn't supposed to do, or something that is wrong. Maybe used the wrong instrument, or he came to the operating theater drunk, or he didn't prepare the patient properly. So if this is a known complication and it is a complication that takes place, then it cannot be said to be negligent. It can only be negligent if it is shown that the surgeon did something that is not supposed to do it. There must be an error of commission or omission, and then only you can say it's negligent. Thanks.
Okay. So I'll take both these points. So I'll put up another question to the audience. So I'll take both these points are accepted. So I'll put up a question from the audience point on the behalf of the patient, right? So I'll say that, see, again, I went in with a problem. It was not a bleed. The problem was the aneurysm. And I was completely okay before the surgery, right? I didn't have any paralysis before the surgery. I just had some headache. I didn't have any paralysis. Now I have gone into the surgery. This rupturing the aneurysm is something that even the surgeon knows he should not do. That is not the aim. He knows he should not do it. That is not what he should have done, but that has happened, right? So that's a mistake. So it's definitely a mistake. That's not what the surgeon intended to do, but it's a human error. So now I have gone in with a headache. Someone's done a human error. There's no question of anyone else. Like there's clearly, it's only the surgeon. He was the one who operated. He has clearly ruptured it during the surgery. And now post this, I am having this major loss, right? So now that person is asking for justice, saying that if I have gone in and someone's human error has caused this problem for me, then why should I not be compensated? Why should I not be compensated? Or who is going to compensate me? So anyone?
Yeah, I would like to answer a couple of things.
I think if you sorry.
You can't characterize. you can't characterize this
One.
as a...
I'll just let Mr. Shivai just reply to that again, and
Yeah,
then
yeah,
I'll
please,
come
please, please.
to
Sorry,
Dr.
go ahead, go
Venkatesh.
ahead.
Yeah.
Yes, Shiva.
Okay, the situation will be like this. Yes, there's a difference between justice and law in the sense that the person went in for an operation and he was perfectly healthy, he didn't have a paralysis, and the paralysis occurred after the operation. So therefore, if you're looking for justice and compensation for that, it depends on the circumstances that happened. If there was no error that took place, on the side of operating or anything like that, the only thing that the person would stand on is if in the consent, the complication was not explained to the patient. Because if the complication was explained to the patient and the patient accepted the risk for doing the operation, then it's an acceptable risk that the patient undertook themselves. But if you do not explain it to the patient and that happened, then you got a vicarious liability there because you didn't explain it to the patient. However, compensation for a complication only occurs and will be paid for by medical negligence if there was some mistake that the person did, error of omission or commission. But if something has happened as a consequence of the operation,
Okay, so Dr. Venkatesh?
I'm in agreement with Dr. Shiva Pillai, but I would put it this way. When it comes to the practice of medicine, there are always risks and benefits. If the risk of dying because of the disease is much higher, the human endeavor by using the application of an uncertain science is to help them. And the benefits and the disadvantages, and if the risks, I mean, all these things have been communicated in a language with an informed consent. And if the patient understands that he may become paralyzed because of spontaneous rupture of the aneurysm, or if it can be cured by a surgical procedure, which also carries a small risk of aneurysmal rupture and paralysis. And if this information has been communicated to them, then it cannot be characterized as a mistake. I have another viewpoint. Characterizing anything and everything that happens within the hospital in the course of treatment as a mistake is not just prevalent amongst the lay people. For want of a better word, they call it as mistake. Or the intention here is to make someone better. And during the process, the right expression would be human error. And human errors happen in a variety of situations. I'll give you a classic example. I have a scenario where this aneurysm is a clear case. What you have not given us is information whether this particular surgeon has done his due diligence in documenting it, getting an informed consent, explaining to them. And once the patient has agreed to it, then obviously the risk is acceptable to the patient, and therefore he cannot be held liable to any kind of open to any kind of legal action.
Okay, fine. Yeah. Point taken. I'll get to it. So point taken very well. Okay. Someone else had Dr. Stephen had their hand up.
Dr. Satvik, please.
Dr. Meenakshi.
Sorry for the interruption. See, what I feel, you mentioned that you are going to enumerate 11 scenarios. So even in the beginning, if there is such an extensive discussion, I think we will run short of time. So please, we will go at the end. We will go for a complete discussion because it is 8:22, 22 minutes over. Even it is only 2 points. So sorry.
No problem. Yeah.
Please, we will finish 11 scenarios because we will get reviews, and the judgment is given by many people when the justice is already here. So we will wait. Please go ahead.
True. Okay, right. So I'll take that. So we'll just proceed a little bit with the talk. We'll obviously again come back to everyone's opinions at the end. So is it medical negligence? Okay, so that's the question. So the point is, to err is human. Okay, so human error. This was definitely a human error. There is an error here. So it is not just in the normal course of the surgery. It is definitely a human error. But even the law understands that to err is human, no matter how good you are at your craft, right? So it doesn't matter if you're a junior doctor, you're a senior doctor. So the reason I put Sachin Tendulkar is maybe some of the younger doctors don't agree with me, but to me still the god of cricket is still Sachin Tendulkar, right? So even he maybe put in so many years of experience, probably the best at its craft, even he makes mistakes. So we definitely, to err is human. So, and the law understands that point. But there is a difference between human error and negligence. There is a difference between mistake and negligence. That's very important to understand. Now here, many doctors, first thing what they try to explain is that this is not a mistake or something. This is definitely a mistake. This is definitely a human error. But the point is that it is not medical negligence. It falls as medical negligence only if it falls below the standard of care. Only that would be considered as negligence. Now there's 4 Ds that are required to establish medical negligence, just for to easy to remember. So the first is duty. There has to be a patient-doctor relationship. This case, it was established. There has to be a there has to be a damage. That means there has to be a
Satvik,
problem that has been caused to the patient.
If you think your slides are on, I think they're not. So if you're talking without slide, that's fine. But if you want, I think you stop sharing your screen.
No. That's fine. That's fine. I have very little on my slides. I usually have very little on my slides.
Fine.
Yeah. So the other thing would be, like I said, damage. The next thing is direct causation. That is something the doctor has done, has caused the damage. So if you see, all of these 3 points these 3 categories are satisfied in this case scenario that I gave you. The point that is not satisfied is, like you all were mentioning, is that only if it falls below the standard of care. That means some other doctor who is establishing the same normal standard of care. This need not be the most experienced surgeon, may not be the top level surgeon. So a basic standard of care needs to be established. And only if it falls below that, would that be considered as medical negligence. Okay. So that's the first point. So we'll go through the scenarios a little bit quicker. So another scenario, you're on ward rounds. Patient has hyperkalemia, right? So the consultant has seen the fact, has advised calcium gluconate, right? So that's the correction for high potassium. The consultant has advised this. Now the postgraduate there writes the wrong dosage, okay? And the patient develops an arrhythmia. The ECG is done. Don't ask me what are the findings in the ECG. You all will know it. No orthopedic surgeon. I have no idea. I'm as maybe same as Justice Kannan in understanding that ECG. So postgraduate writes the wrong dosage of calcium gluconate, and that has caused an arrhythmia, okay, and a myocardial infarction. Now this is a serious thing. Patient again just has hyperkalemia, ended up with a myocardial infarction. A heart attack has happened to a patient because, again, human error definitely there in this. Now we realize, okay, human error. But now in this question, I'll ask for this scenario is, who is legally responsible? Is it the consultant? I mean, the patient came for the consultant, right? Patient is admitted under the consultant himself. Or is it the postgraduate? Now, the consultant has advised the correct dose. He knows what he's talking about. He has advised the correct dose. The postgraduate has written wrong. But now, is the postgraduate responsible? He is a postgraduate, means someone who is in training, right? So is this person responsible? So the question is, how does the law see it? Who is exactly responsible? So this comes to the principle of vicarious liability, right? So this is a general legal principle. It does not mean that it's applicable only to the medical field. It's a term which is applicable to any field. What that means is that a senior is responsible for the actions of their junior, right? So that is what vicarious liability in general means. And the same thing applies to the medical field. So that definitely applies to consultants. So if you have people working under you, they make a mistake, you are responsible. Now you can argue that, what can I told the right dose, this person has made a mistake, so why should I be responsible for someone else's mistake? But that is a principle that exists and you will be held responsible. So that is something you must understand. That is why it is important who you have under you. It is important how you monitor them, how you train them. It is important because you cannot wash off your hands saying that this is a different individual, this is a different person who's made that mistake, and so you are not responsible. Same principle applies to hospitals. Hospitals cannot claim. So you'll see in a lot of lawsuits that hospitals are included. And many hospitals think that, this is a consultant's mistake. In the operation theater, how is it my job as a hospital administrator? How is the hospital responsible? No. So even the hospital is vicariously responsible for its employees. So that includes your consultants, that includes your postgraduates, that includes your junior doctors that are there. Now, the other question is, why does it exist? So why should I be responsible for another person? So now it's a big debate on, why this exists and all of it. But a simple thing to understand is, otherwise what would happen is it would just be a blame game, So the hospital will say it's the consultant will say it's the junior doctor, and that junior doctor is not going to have anyone to blame. So at every point, at every reason is just going to become a blame game, right? And then there's going to be, no one's going to take responsibility. At every point it's going to be rather blame rather than responsibility. And so then that is why this principle exists, that whoever's there needs to be responsible. This lower person is responsible, but even the higher person is responsible. Now, the other question is the junior doctor absolved of all liability? So can, a postgraduate be like, okay, you know what, I am not going to be held responsible for anything. It is the consultant's patients. Whatever I do, I can be reckless and think. So no, that is also not true. Doesn't mean just because the senior is also responsible, doesn't mean that the junior doctor is completely off the hook. So he is also responsible, just that along with him, even the senior would be held responsible. Right? So does the senior have a defense? Yes, in some cases, the senior does have a defense, especially if it is proven that the junior doctor had a different intent. Now, if you hear of some cases in the US, a case became very famous where a nurse intentionally was going and basically injecting babies with an injection and causing their death. So is the consultant responsible in that case? There are babies admitted under them, but no, if you can prove that you have taken all the measures and what that person did had a different intent, or it was their own intent that they did it, so then that would be a defense for the senior doctor. So coming to the next scenario, so you're in the OPD, patient comes with acute abdominal pain, ultrasound shows acute appendicitis. So this is an OPD scenario, okay? So doctor has advised the patient for admission, has advised that you need to undergo immediate appendicectomy. Patient has not listened, right? Patient has not listened to the doctor's advice at all. Not listened, gone home. Common thing that happens. 2 days later, the appendix ruptures and the patient passes away. Now the patient's attenders have filed a case against the doctor saying that the doctor did not give us right advice. Now you have given them, you have told them that they need admission, but now they say that, doctor has not advised. We went to him, he has not advised. Now, what do you think will be the first thing that you will think of? You will say, no, I have definitely advised them. And if you are prudent with the law, you'll say, no, I have even documented. I have documented that I have advised the admission. Now, but what if that patient doesn't show your OPD sheet? What if that patient says, I came to him, he told me these things, he didn't show any, he didn't write and give me anything, or he wrote something, I don't have it, but he never wrote to get admitted. Now, what will the judge do? What will that judge do? It's a basic scenario of he said, she said. So the patient saying one thing, the doctor saying one thing. Who should the patient, the judge believe? He obviously he has some sympathy for the victim, that patient's relative has passed away. Now the doctor is saying he is also an expert, respected expert. But now who do you believe? How should the judge decide who to favor? Okay, so the judge decides not based on any of this. The judge basically decides on what is documented. What is documented. Now you cannot say that you documented it in your OPD case sheet and then gave it to the patient. Now the patient might have done anything with it. He might have thrown it away. He might intentionally, knowing that you have documented it, not produce it in court. Then what do you do? So the point is that there is a responsibility on the doctors and the hospitals to maintain medical records. And the law says that it is your responsibility also. It is not unlike what we think. We think, okay, it's the patient's responsibility to bring all the medical records. But there is a legal responsibility of the doctor and the hospital to maintain that record. And especially, even if there is no legal responsibility, I highly recommend that, because again, then what the patient's going to do is, again, like this, selectively going to remove things that favor their case. So 100% you must save all medical records for all your records, including OPD sheet, because this is a thing that we don't do. Maybe case files, all of it, hospitals keep a record, but OPD sheets is something that we often ignore. That's why I gave you that case scenario saying that it is an OPD case. Okay, so all medical records, including OPD case sheets, have to be preserved for 3 years. And if it is a medical legal case registered MLC, it needs to be registered for 10 years. And if there is an ongoing legal battle, or you feel this patient is going to file a lawsuit, something like that, then it's better to save it indefinitely. Okay. So all medical certificates, another thing that we often miss is medical certificates, this medical leave, all of that. We think they're small things, but there is a legal responsibility for you to keep a record of it, right? Because they will misuse it. They will do something else. then the court is going to ask the doctor, where is your copy? What have you written? Show us, right? So then that becomes very important. So now I'll come to another case scenarios. Patients come to the OPD. You have prescribed an antibiotic for the patient. Patient develops an allergic reaction to that antibiotic. Okay, family sues the doctor saying that why did you prescribe this medicine when that has caused an allergic reaction and caused all of this problem to the patient, right? So is the doctor responsible? Thing is pretty clear. Allergic reactions, not the doctor's responsibility. You cannot predict who is going to have an allergic reaction to what medicine. It can be an allergic reaction to any medicine. So that is not considered medical negligence. But that does not mean that there is no legal risk here. Okay. So I will inform you that every patient, you must ask if they have any allergies. You must document if they have any allergies. Because now again, the thing is, some patients, they may be a known allergic reaction. They may say that they have told you in the OPD, but you have not documented. Now, again, if there is no such documentation, it becomes a he said, she said. He'll say that I told you in the OPD. They might not have told you at all. They might have forgotten. They might not have bothered to tell you. But then it becomes a he said, she said. So you must document whether there is an allergy, and if there is no allergies, that there are no allergies. So you must document that. And if an allergy occurs, there's absolutely no reason for you to fear. You must identify it and stop that offending drug and treat the allergy accordingly. So another scenario on the ward round, similar to what we discussed earlier. So now patient has hyperkalemia. Consultant has advised calcium gluconate. Okay. Now the junior doctor has documented the correct dose also this time. Okay. But the nurse gives the wrong dose. Now you have advised something. You have advised the 0.1 milligram. Patient has, the nurse has given some medication as 1 milligram. Again, wrong dosage caused arrhythmia, caused a myocardial infarction. Now we have established that the consultant is somewhere partially responsible, right? But the question is the nurse also responsible? Okay. So can nurses be sued for medical negligence? Yes, even nurses can be sued. Even junior doctors can be sued. Even nurses can be sued for medical negligence. So they can be sued in civil, criminal, and consumer courts. In fact, nurses can face disciplinary actions by the nursing council, similar to how we have our medical council. Nurses have their nursing council, and they can also face repealing of their license, everything by the nursing council. So even nurses should be careful. So it's not that, okay, we're nurses, doctors, anything happens, doctors have to handle. No, everyone's going to be held responsible if something happens. So coming to another case scenario that we see often these days with the increasing social media and everything. Okay. So patients come, uncontrolled diabetes, very common. General surgeons will keep seeing so much of this. Uncontrolled diabetes, cellulitis, not resolving. You have given the antibiotics, correct antibiotics, everything. Patient not resolving. Patient says, this doctor's medicines are not working for me. I'll go to another hospital. Gone to another hospital. There they have said, you know what? Yeah, I mean, it's tried everything. Now you need to undergo an amputation. Go ahead, amputate. Now, what does the patient do? Doesn't say anything about the doctor that's treated. They will say, that first doctor, they will feel, now my leg has been cut. I went to this doctor so much before, and he gave me all these medications. It didn't work. There must have been something wrong here. Now, what they may think is, who will, go to more than the litigation that they face. There's a lot more people who will sit and badmouth doctors. That's 100% something that every doctor here would have realized happens. So what they'll do is not even litigation. Litigation, though, you can still fight. They will then go and tell all their people around that, see, I lost my leg because of this doctor. Okay. So then what can you do? You can't sit and they might have told 100 people. Can you call 100 people and tell them that, no, see, explain this diabetes, uncontrolled diabetes. That is the reason of cellulitis. I've given the right antibiotics. It is correct. But, uncontrolled diabetes, what can you do? This is because of the uncontrolled diabetes, all of this is the protocol. I've followed it. Can you sit and explain to every lay person? Can you sit and put out, if they have put it on social media, can you put it out on social media again saying that, no, see, this is the protocol. This is what my association advises. Can you do all of this? Will that be effective? That we know that that's not going to be effective, right? So this is a plain case of defamation. So, right, they've gone ahead, said all of these wrong information. So the question is, we get a lot of calls I get from doctors who are annoyed, who say that, can a doctor or hospital sue a patient for defamation? They have gone, I have built my reputation over so many years of hard work. And this one patient has gone and, spread all the wrong things on completely no standing at all, absolutely no standing, medical standing at all to have any problem, but they've gone and, caused all of this. So can you sue? Yes, 100% you can sue for defamation. Okay. But one point I would like to point out here is, so the basic requirement for proving defamation is the fact that the impact of words and actions has had an impact on your reputation. Now, the problem with defamation is, how do you go and prove all of these things? There's quite hard to prove defamation. That's why even if you go to lawyers, they will say in most cases you don't win those defamation lawsuits. But another point that, many of my clients would say is, now say the litigation has happened, right? Say they have won the case. They have proven that, there is no legal standing. The judge has given the verdict in favor of the doctor, saying that no, there is no problem in this. The doctor has not made any mistake. It's not medical negligence. After that, lot of patients ask, the doctors ask me, no, now shouldn't the court give a, shouldn't they file a punishment for the patient, considering that, this is a frivolous case that they have filed. They didn't have any legal standing. Even judge has said that no, I was not at fault, but still they have filed this case, and this case has caused so much damage to my reputation. Now he has gone and spread, it has come in the media, he's put it on the media that he has put all of this case. Now shouldn't I get some compensation for that? Shouldn't I be refunded for all of that damage that he has done when it is proven that the patient is wrong? So the point I would like to point here is, if the patient has only filed a litigation, right, even if it is a wrong litigation, that cannot be used as a reason for defamation. That doesn't count as defamation. Even if it is in court, there is no legal standing for that case, that will not count as defamation, even if the verdict is in your favor. Only if they have gone ahead, done something, usually in social media. Again, that comes back to this point. The fact that the impact of words and actions had an impact on your reputation. Just filing a case cannot be proven as the fact that it has had an impact on your reputation. Okay, so that's another thing that you need to remember when it comes to defamation. So another scenario, maybe this is more with doctors who are dealing with sicker patients, who basically ICU doctors, or dealing with critical patients. Patients admitted in the ICU, patient is in a critical condition. Suddenly you find yourself in a situation. I put this case because I didn't think it would be that common, but I've had a friend who went into this scenario, called me in a distress call in the middle of the night saying this thing. So patients in the ICU in a critical condition, tells you who they want to give their property to. They know they're kind of on their deathbed. They say, you know what, I don't like this son. I like this son. I want to give my property to my daughter.
To the
and
doctor
no one else
himself.
is there. So
did you suggest, Satvik, to the doctor himself?
Yeah. So that if you're a known doctor, that becomes an even more problem. If you're a family friend, that becomes an even more, you're assumed to be biased in this aspect as well. So now, should you record the dying wishes of the patient? Is this a dying declaration? So then coming to the point is, dying declaration is again a point made by a person who is conscious and knows that their death is imminent, but they need to be in a state where they can make such a statement. But rather than going into the details of what a dying declaration is, what a dying deposition is, all of that things that Justice Khan would be dealing with, but rather than go into that, just point out that dying declaration only deals with concerns when it is related to the cause of the death. So if the person is talking about their property, all of that doesn't have to do with you. We are doctors, we are dealing with their medical problem. If they are telling you a point as to what caused their death, if they are saying, no, this person pushed me down the stairs, that is how I had this fall. If they say, no, this person shot me, if they say that this person did something to me that is causing the death, then that's a dying declaration. Then that is your responsibility to go ahead and document it. If it is related to their property, something else, their family issues, that's not our job. That's you can inform it to the police, you can inform it to the lawyer to come ahead and take matters ahead, but that's not our job basically. So if it is related to the cause of death, it can be recorded by any person. As per law, it can be recorded by any person who is present at the time. Ideally, it is better to have 2 witnesses there. If you can have their family members, that's better. But if you don't, even if they're not there, 2 witnesses, any nurse, anyone who's there in the hospital, you can document that. Okay, so that's one. And it can be oral or written. Doesn't always have to be written. Can have an oral dying declaration. If you can then go ahead and support that in court as well, it's okay. So coming to another scenario, this is closer to my field. So this is something that we face as orthopedic surgeons. So patient has come with knee pain, undergoes a knee replacement surgery. Patient is not happy with the surgery. Post-surgery patient is saying that, see, I still have knee pain. My knee is still stiff. So what has been the use of your surgery? What has been the use? My problem is still there. I am still suffering from knee pain following the surgery. So after paying this much, what's the point? So there's definitely some fault with your surgery here. You told me that, you're doing the surgery to relieve my pain. Why has this pain not gone away? Okay, now the surgeon, something that we say or that happens is the surgeon says that the patient was advised to do physiotherapy and exercises for 1 month following the surgery. Patient never did any physiotherapy. Often happens. Sometimes patient moves away to another city. Sometimes patient doesn't follow up with you, has gone far away, and sometimes just doesn't want to follow up, has done the surgery, but doesn't want to do the physiotherapy afterwards. So now who is to blame? Who is to blame? The surgeon. Now it's his surgery. Aim was to relieve the pain. Real pain is not relieved. Is the surgeon responsible? So this comes to the concept of contributory negligence. Okay. So this, even the law understands that the patient has a duty to take reasonable care of their own health. It cannot be, even the law understands that it is not that the patient has come to the doctor, now everything is in the doctor's hands. It can't be that. There is the responsibility of the patient to also take care of their own health. So this is a very useful legal defense in cases for the doctors, right? So especially if you have documented some advice and patient has not been following that advice, then it's a very useful defense in your court to say that, see, I have done this. Even if there is a mistake, sometimes some of the cases that have happened, even if there is a mistake from the doctor, the fact that the patient has not followed the doctor's exact advice and has added to the problem. So then the judges basically recognize that, yes, the doctors are at fault, but even the patient is at fault. So maybe the punishment won't be as much. So it's a very useful defense that you can use in court. But for this defense to be used, it is very important to document what advice you're given, not just medication, even physiotherapy advice, even the physiotherapy advice. And there's certain case laws that that where the learning is basically that some of the very useful defenses in such cases have been, not only have they documented whether what physiotherapy they have advised, but the fact that the patient is not following that advice, even that needs to be documented. Only then is the judge, capable of giving that verdict in your favor. So you need to document whatever you're advising and the fact whether the patient is following that advice or not. Very important, will come to your help if there is a lawsuit. So another point, so this is something that relates to mental illness. Okay, so this is the reason I put this is I'm not talking about psychiatrists dealing with mental illness. I'm talking about general doctors dealing with mental illness, right? So this case scenario is that. So a patient comes, known mental illness, maybe depression, maybe schizophrenia. Patient has come, you're a general surgeon, patient has come for a lipoma excision. Now, a common thing that many of my colleagues will ask is, can we take consent for this patient? He has a mental illness. So can I take consent for this patient? If I can't take consent for this patient, who do I take consent from? Right? So common thing that we got this question from a lot of our colleagues. So now they'll think, most of the doctors think, okay, you know what, why all this doubt? Let me take the consent of the attender. Let me take the consent of whoever's there with this patient. Maybe their mental illness patient giving consent not valid. Let me take the consent of the attender. But now what if the attender says no? What if the attender says no, I don't recommend, I'm not taking responsibility. I don't recommend this patient undergo the surgery. He wants to undergo the surgery. Now I won't sign it. Then what? So now what do? You're at the attender's not ready to give consent, or maybe there's no attender. Patient has said, okay, I'm an adult, I want to get this surgery done. Then what do you do? Okay. So the point, this is clearly established in the Mental Health Act of 2017. Okay. This is something that that is close to mind, that we as doctors have to destigmatize mental health. We have to destigmatize mental health. Now, there is already a lot of stigma associated with it in society, but from my own personal experience of viewing, a lot of that stigma is added on by us. That stigma, even we feed, even we as doctors, knowing all of the facts, even we feed to that stigma around mental health. And creating an issue of consent when it comes to a mental health person is again doing the same thing, adding to that stigma. When you add more and more barriers for that patient, It is saying that, no, we are not treating you as a normal patient. So what does the Mental Health Act say? A mental health patient should be treated same as any other individual. Okay. And this is not should be nice. No, it is the right of the patient. So if you are not doing that, you are denying that right to that patient. So please understand that not only are you in your attempt to safeguard yourself more, if you are denying someone that right, they have the legal right to sue you for denying their right to be treated as any other individual. Right. So now coming to that question of that consent in that case. So Mental Health Act has clearly stated that if the patient, be it with mental health illness, any illness, I'm not talking just depression, schizophrenia, anything, when is that consent valid? Okay, that's the question. When is that consent valid, which you take from a patient who has mental health illness? So the point that the act says is that if that person can comprehend what you are explaining to that patient, right, can comprehend what you're saying about the surgery, why it's required, what the pros are, what the cons are, what the possible complications are. If that person understands these things, they are capable of giving consent. Does not matter what their other comorbids are. Like how we don't say, okay, if a patient has diabetes, is their consent valid? No, same way, mental health illness as well, a comorbidity. But if they can understand what you are telling them, they have the right to give. Their consent, what they give is absolutely valid according to the law. Now, despite this, a question that doctors ask me is, I'm sure this would be a doubt that doctors would ask if I open it to the forum now, but for the shorter of time, I'll just assume that that's a question that's been asked to me, is that they will say, okay, now how should I as a doctor decide if this person is able to comprehend what I am saying or not? Right? So that is a question. Should I ask a psychiatrist? That is what many doctors do. They will give a reference for a psychiatrist to say whether is this person of sound mind to give that consent. Is this person comprehending or not? So there was a case that ended up in the courts like this, and the act recognizes that doctors may end up doing this or were doing this. So what that act has said is, how do you as a doctor, if a normal patient walks in, how do you decide if that consent is valid or not? Leave mental health. Patient has walked in. How are you deciding for any consent to be valid, whether it is mental health patient or not? That consent to be valid, that person has to comprehend, right? So if a person who's absolutely in a comatose state is giving consent, that is not valid. Why? Because he is not in a state to comprehend. So if a normal patient walks into a OPD or in the hospital, how are you deciding? Are you giving a psychiatrist opinion to decide if this patient can comprehend what you're saying or not? No, right? So why, if you just need to apply whatever you apply to a normal patient. So how to a normal patient you decide, okay, is this patient able to comprehend what I'm saying? Is this patient able to comprehend the complications I'm saying? Yes, then that consent is valid. So same thing with a mental health illness patient. Nothing different. Absolutely nothing different. If that person is able to comprehend what you're saying and you feel that person is able to comprehend what you're feeling, that consent is valid. You do not need a psychiatrist to tell that the person is of sound mind. You do not need a psychiatrist to tell you that that consent is valid. If you feel that the person is able to comprehend what you're saying, that consent is 100% valid. And I think we must follow this. We must not, at the expense of trying to safeguard ourselves, not deny the right of mental health illness patients, right? So I think we must destigmatize this by following this point that is laid down in the law. Right? So I'll come to other scenarios. So I'll run through these last 4 scenarios a little bit quickly. So this is basically with maybe obstetricians face this. A pregnant woman comes to the obstetrician, history of rape. So suddenly, you get worried. Should you notify the police? Should I deal with these cases? Some violence, all of that, or maybe some assault. It's a police case. Should I do something? I don't know the law, all of these things. So in all of the situations where you're not sure of what the law is, ideally, yes, definitely inform the police. But so again, rape and sexual abuse are not listed under Section 39 of CRPC. That's not a mandatory reporting. It's different if it's a child under 18, but okay, normal rape and sexual abuse, not a mandatory report. Important confidentiality. So you must maintain the confidentiality of such a thing, but you can inform the police about it. And the basic thing is, if you are in doubt, provide basic medical care. You are never wrong. As a doctor, no judge, no court is going to say you are wrong to provide medical care. So please provide the first aid, provide what medical attention you need to. If you are not sure of the legal thing, then take help. Maybe a legal advisor, maybe a senior, your colleague, all of that. If not, inform the police, all of it. So all of that, but don't be scared to provide the basic medical care to the patient. Okay. So that is not going to wrong. Stabilizing the patient, all of that, you'll never be wrong in providing basic medical care to the patient. Another scenario, okay, patient has severe psoriasis, patient has advised methotrexate, a risky drug. Patient has developed liver cirrhosis because of the methotrexate. Okay, so now that is the doctor responsible? Something that they have prescribed, dangerous drug, gone ahead, caused liver cirrhosis. If not the doctor, is the drug company responsible? Is the drug company responsible for, creating such a drug, caused damage to the patient? Again, so everything, the law basically understands that there's a risk and benefit to everything. So there is a risk benefit ratio. You must weigh the pros and cons and then decide. So even if there's drugs, so now maybe methotrexate is one, but cancer drugs, all of these multiple drugs have dire side effects, or any drug for the matter of fact, even paracetamol can cause liver cirrhosis, all of it. So any drug has its risks, has its benefits. So you must weigh the risks and benefits. Manufacturing approval. So is the manufacturer responsible? As long as the manufacturer has all the required licenses, they are also not responsible, right? So they will produce drugs which have certain complications, but as long as they have the necessary licenses and it's approved, it's not you can't really sue the manufacturing company either. So if there's a adverse effect to a drug, nothing to worry. You must just monitor, identify that there's an adverse effect. Don't try and hide it from the patient. Don't try and say that no, this is because of the effect of something. No, there is no problem in saying that no, this is a drug that I have prescribed. This is a complication that has happened because of the drug. It is an adverse reaction of the drug. Doesn't happen to everybody. Happens to some people. Unfortunately, you're among some of the few. That doesn't mean you're responsible. Doesn't mean there's negligence. That doesn't mean there's a problem. It's just a known effect. There is a risk benefit. Unfortunately, for that patient, he has faced the consequence of that. Be open about it. Monitor it. Identify it. Document it. And manage the side effect that has occurred. So take home message. So prevention is better than cure. Okay. So the reason why I'm talking about all of these aspects is see, once you have a litigation, your lawyer is going to advise you on what you need to do. But the point is, a lot of these aspects, if you are aware of it initially, these are all everyday case scenarios that I've said that generally all of us face in the hospital, is that if you can go ahead and make changes to your practice now, that will save you not only the chances of getting sued, but if you get sued as well, that will be a great defense for you. After you get sued, there is very little that you can change, very little you can do. So you need to be aware of these things before you need to enforce them into your daily practice. So there is a saying that ignorance is bliss. Why worry about all of these things? I read forensic medicine in my third year, and now I've forgotten whatever MBBS I've read. Ignorance is bliss. I've been living peacefully with that. No, absolutely not. Ignorance is not bliss. Knowledge is power. Okay. So you must be aware of what is right and not right. Only if you're aware of what is not right, can you then go ahead and make that change. If you think that everything you're doing is right, you will never go ahead and make any changes. And the last point is share. So it's again, credit to Dr. Vidya, Dr. Sundaram for moderating this session about this fact and spreading awareness about this. So one thing that I find is that we rarely as doctors share these points. So if you are faced with a litigation, so many doctors, sometimes more than the fear of defamation, more than the fear of what the patient is going to say to other people, they are more scared of other doctors getting to know about this lawsuit. They try to keep it low, all of that. There's absolutely nothing to be ashamed of. Like I said, human error, there's nothing to be ashamed of such things. It's happening. It's increasing. It's likely that most of us are going to face such a problem. There's absolutely no harm in sharing with it. In fact, if you share, you will get so much more inputs. You will get so much more help. And the biggest thing is you will lose a huge burden in your mind as to what your colleagues will think. Very likely, we have seen it in so many of our clients, very likely that you have certain worries that what people will think. Your own colleague has those exact same worries. Is in the same boat as you, is facing the same problem from patients, all of it. If you just share those points, it would help both of you all so much more. Okay, so that's another thing that I will leave you all with. So since I usually give a lot of analogies, so I leave you with my with some of my last analogies. So there's this saying that ostriches they bury their heads in sand. Whenever there's a problem that they face, they bury their heads in sand because they think that if I can't see the problem, I bury my head, the problem goes away. Is that true? Absolutely not. But I would like to point out here that this is a myth. This is a myth. Even the ostrich does not bury their head in the sand. The ostrich, if faced with a problem, the ostrich runs. That's what they do. So even, I'm saying this because even the ostrich knows that if there is a problem, you must see it, you must address it. There is no point of having this problem of of litigation around us and saying that, no, I am going to bury my head in the sand. I am not going to hear about it. So it is not going to come for me, right? So even a bird knows that, just burying your head in the sand is not going to work. So we as doctors, we as human beings, especially as doctors, should be aware that that would not be a good strategy. You have to be aware of all of these points. Coming to the last thing, so I'll give you a point about perspective as to what me and my firm does. So this is a task, simple. A basketball player, all he has to do is throw the ball from this point into this point. That is what the patient would see. I have gone to this doctor. He needs to solve my problem, right? So he needs to do this. Just put the ball into the basket. That is what he needs to do. No matter what you explain to them, they will see it this way. That I had a problem. The job was to solve this problem. Now your colleagues and the judges who are learned, they know how the law works. They have consideration for all parties. They realize that it's not as simple. Now, even in that game, that basketball player is not just throwing a ball. No matter how much he's practiced, he has to run around. He is fatigued. There's so many other factors there. So all of these things are there. So every case is not as straightforward. There may be different factors. But only as doctors do we know from first hand how it really is. So this is the scenario from the player's point of view when he is shooting that same free throw. So there's so many other things. There's so many other things. It's just not about throwing the ball into the basket. There's so much crowd around. There's so much of complications around. There's so much of variability. There's your opponents there. There's the pressure. Biggest point, there's the pressure. You can do all of these things sitting in your room. You might do it 9 out of 10 times, but imagine there's a pressure. Someone's telling you that there's someone's life at stake here. So then are you going to be able to reproduce the same results? No. So that's the same thing. So it's all about perspective. So that perspective is why I started this firm, to realize that there are definitely so many good lawyers. There are so many good people helping out doctors and that you can take services from. But the reason I started my own thing is not to prove that I had some great experience or great knowledge, but the fact that that knowledge with a perspective of what doctors actually face can maybe add and help doctors more. So that is why that is the firm that I run. Basically, we help doctors. We only help doctors. We don't represent or advise patients against any doctor or hospital. So we do it basically only for doctors. So I would like to thank again Marvelous Medicine, Dr. Vidya, for having me for this session, and Dr. Meenakshi, and again, Dr. Kannan, for patiently listening to all of these things that I've been saying, that he knows and does everything, but has been patiently listening to all of these things, and to everyone here as well. So again, all of these things, not the real expert here is Justice Kannan. He's the real authority here. But my only purpose is to basically ignite the point that we need to be aware of this. We need to be thinking about it. It's not about whether you know everything about the law, you know the exact nitty-gritties, but the fact that you're just thinking about it, you're considerate about it, is what my aim of this talk is.
Thank you, Satvik. We've had one of the largest attendance in recent times, so not to worry. People are aware and people are interested. And when I think sometimes we are also a little I won't say snobbish, but we are clannish. Like when a doctor is talking about something, it resonates better than same lecture being given by a lawyer or a judge. So that's why I wanted you to do the talk and have the experts chip in. Over to you, Justice Kannan.
Yeah, I'm truly amazed, and I congratulate Dr. Satvik to have done. If I'm called to speak about medicine, full-time medicine, I don't know how much of mistake I could be making. But I can say from the reverse, from a doctor to be saying so much of law, which is so correct. I'm so happy for you. But there is one thing which I need to generally sound, because the topic was about the law that all doctors must know. But there is a general obsession about knowing aspects of medical negligence and consent at all times. There is so much else about law than merely this. In fact, issues of, I had even indicated to Dr. Vidya what we could be talking about. Medical ethics. Ethic is a very important thing. Ethical consideration of what is lost and how the latest regulations of what have come to you through the National Commission in 2023 is important. I would want probably a session to be made on that, because we dump it at all times. Again, assisted reproduction, or what happens there in surrogacy arrangements or IVF procedures, and mistakes of what happened. What is the new change which has happened? The kind of judge-made law, judge-driven law has come to be now tempered through a legislation which has come in 2021. Significant changes are happening, because we only know surrogacy of some person who is gay, who is not married, having a child. Or there are popular couples, cinema couples, where they have 2 children, the third child is taken. Or there is a very famous couple in Tamil Nadu who marry and within a year they take a surrogacy. All which are wrong, which are shown as examples, which are against law, are shown, and as though that is the thing. So it's essential to know that. And things again like organ transplant, where Tamil Nadu is probably amongst other states is doing exceedingly well. And you had the issue relating to a living will, informed consent, all that coming in a very big way. And even advanced directive. So much of law has come through that legislation. So therefore, that probably it needs to be a greater awareness in that. I'm merely flagging some issues of law or what is not discussed at all, but which are probably very relevant. If the topic had been medical negligence and doctors, I would understand an emphasis given with 12 examples, like what Dr. Satvik did. But then if you're talking about law, what we are really talking, what the doctors must know. That is surely, for instance, again, matters relating to the stereotypes, male, female. And then you have transgenders. Then can there be a sexual reconstruction surgery? So what comes with it? Ambiguous genitalia. When can surgery be done? Whose consent is taken? Again, medical termination of pregnancy. What is the appropriate time? Beyond 24 weeks. And if beyond 24 weeks, if a person says, I'm exceedingly poor, I've already had 2 daughters, I'm afraid there is going to be a third thing, it was unintended pregnancy, do we do something about it? These are all pulsating questions which have come before the court and which have been answered to extraordinary things. So therefore, that I would say is merely something for Dr. Vidya and all others to think of and know that there is something beyond what we discussed today.
Yeah. I'll be happy to tell you that we already did a session immediately after the surrogacy law changed. We had done a session on that with the details. And then we've done one on the ethics of organ transplant as well. But there are so many topics, and we'll be looking to you for help to do some other sessions.
Hello, sir. I started with saying Satvik did an extraordinary job. I'm not now faulting anywhere.
Hello.
But I'm telling generally, when we are talking about a subject such as the laws that we need to know, that there is really a lot more than mere medical negligence, is what I wanted to give. And on 2 or 3 things of what Dr. Satvik already said. See, no 2 lawyers agree, and that is why you have 2 sides, and that's why you have a 3rd judge, and that is why you have multiple layers of tiers of litigation. That even that judge who says cannot be stated to be saying the right thing. But some general statements, what came through Satvik, probably I would attempt to say that, and then I'll close, because that ought not to be taken as the last word. We need to be very careful about a certain.
Excuse me, I'm not getting the link on Facebook. It's not coming.
Yeah,
the link on Facebook is saying nothing is available.
It's okay. Our main session is on Zoom. I'm really sorry. So let's just continue with the session. The Facebook Live is just an additional thing. Our main thing is on Zoom. Please bear with the inconvenience.
Dr. Satvik, I should appreciate your enthusiasm in delivering the lecture, not only the content. So just like 10 commandments, you have enumerated everything with 11 case scenarios. So it is excellent. And the way in which you have given an example of a bulletproof jacket, it is applicable, and why the cases are increasing, the medical negligence cases against doctors. All the reasons you have given are relevant even now. But to throw open the discussion, even justice is also there. I want to know two questions personally. One, now can we read legal course, that is law, like LLB, full time at any point of time? That is one. Another one, as there is always a compensation, whether because I have seen a judgment in the National Consumer Forum, even though the doctor is not negligent, the word was like that, even though the doctor was not negligent, considering the sufferings of the small child, because the child was amputated at the age of 3. So they have given 12 lakhs as artificial limb for compensation. But the insurance firm said, see, we have insured you only against negligence. But the court said, even though the doctors are careful and not negligent, then we will not compensate it. So it was like that. But what I want to know, see, even in train traveling or this flight travel, we insure only for that particular period of time, because the train insurance is only 45 paise for every journey. I used to do that. Flight insurance is a little bit costlier, because I don't know why the life in a flight is superior than a life in train. But the same way, I want to represent to the, even the IMA can do that. Why not we insure all the patients entering the theater at their own premium? The insurance firm can fix up a premium, whether there is a negligence or not. At that particular point of time, the patient will have a compensation by the insurance firm. We are doing insurance for everything. So just like a train journey insurance or flight insurance, we can do operation theater insurance. So this is for a global opening. Then because you are talking about informed consent also, because the Samira Kohli judgment by the Supreme Court, the Honorable Supreme Court has given all the factors governing the consent. As Justice pointed out, we people are obsessed, but definitely we have to be obsessed, because any beginning, there will be obsession. This is just like appearing for examination. So once you cross all the stages, then we will inform the junior, hey, don't bother, everything will be very easy. Once after passing the examination, we used to do that. So we have to read and see the lot of strength, because 140 people attending means people know about curricular activities. They know about the medical subject, as the legal subject is entirely different, and the people are worried. Even I used to say, even badly injured head injury patients, we are looking for pupillary reflex. But once a legal notice is slapped on our face, we are running. So it should not be like that. It is also part of the game. So we have to sensitize, and as Justice pointed out, it is a layer by layer. But one point I want to say, Justice also said, judgment differs from judge to judge. There is no fixed rule for medical negligence. It is only the perception of the judge decides the case. So the doctors have to be extra careful. I don't want to say that you have to practice defensive medicine, because as some law is coming, we are not supposed to penalize the patients. So be friendly with the patient, avoid defensive practice, but at the same time, remember, judgment is not about our behavior and textbook. It differs from perception of the judge. Thank you.
Now I see some question there. I'll probably take it away from what was spoken by Satvik, because I thought I will say some general statements, some wide statements which seemed wide to me. I thought I'll limit them, but then I see something which is very important also.
Sir, please complete whatever you intended to say when
Right,
we
sir.
got interrupted.
One is about vicarious liability. It was not correctly stated, because vicarious liability it came through the English jurisprudence of a master being liable for what the servant did. So it was a master-servant relationship it started. then it was in a larger employer-employee relationship where employee does something or workman does something against the directions of the employer. Will the employer be liable because they were creating a situation, exclusion of liability clauses at the time of employment, where you are doing something against my direction, I will not be liable. This again came as a common liability act. Many of this branch of law comes through England and the judicial practices. And this grew to be extended over a period of time. This employment in the vicarious liability, it is fixed because who can bear the loss? Who will be in a position to absorb the loss? Was the question at all times. Employer obviously is better equipped to handle something of what an employee or workman does, isn't it? It's like that. So this principle came to be later done. We are not really talking about a junior doctor, senior doctor. You must see what is the relationship with that context. So, supposing it's a hospital. Hospital calls some persons, makes facilities available. The hospital at that time in that engagement is the employer, because the patient comes to the hospital, and in the hospital it provides a basket of services through several doctors. So therefore, vicarious liability must be understood about how the law flowed. Who can absorb loss was the predominant consideration at that time. And therefore, in a hospital situation and a hospital and an employee, if there is he was giving an illustration of a nurse. The nurse giving an injection, which was the prescription was correct, but she gave a wrong dose. In fact, Spring Meadows case from Delhi is a classic example of that. Spring Meadows case was a case where that the doctor didn't do anything wrong. The nurse administered a medicine which was not correct, and the child went comatose. The hospital was the one which was made to pay. And not just that, it allowed for a new branch of law in India which had never been done before. The child. It provided for compensation for mental agony of parents, which we in the West call as mental injury in USA, and in UK it is called a psychiatric injury. A secondary victim who had not really suffered directly by that, by a cause which is proximate relationship. So therefore, that I thought that vicarious liability must be understood slightly differently. And another thing about to err is human. Therefore, every mistake is not negligence. That's again a very dangerous statement, because we understand this law like this. There is a duty of care. That care was in some way deficient. It resulted in some outcome which was not expected, and that is to be compensated in terms of money. These are the four things which follow one to another. The moment I say I made a mistake, then there is no question. The example of aneurysm, or what you were saying, there have been some responses there in the board where they said aneurysm, where it can explode, it can rupture on it without any mistake on the part. But then Satvik is giving an example where he was rooting for there was negligence, there was human negligence. If you are talking about human negligence, we need to be seeing whether all these four things flowed one to another. Was that a duty of care? A doctor who is an expert and therefore who has the competence to do something, does he do it with that duty of care? Did he fail in that duty in some way? Yeah, he failed. When you're saying now there is a negligent act of what he did, case is closed, period. So don't ask for anything. Was there an intention for him? He had good intentions. He was an expert. That's not the intention at all. This branch of law does not talk about intention. And that brings us to the answer to a question which somebody has asked about criminal and civil liability. All criminal liability arises with some intention, or what we use an expression, a Latin expression, as mens rea. What is the mental state? Did I intend to do that? But then there is one area of negligence which the law recognizes both in civil as well as criminal. That is criminal negligence. Another is civil negligence. Criminal negligence is one of degree. It is so egregious. It is so palpable. The court itself had given an example there in BP Shanta at the time when the issue was whether the doctors must be amenable to the Consumer Protection Act or not. The example given was, if a person goes for a defect in eye of the right eye, and the doctor gorges out the left eye, there is some problem. If the person has a left foot problem and he is operating on the right, or if the doctor keeps a swab inside and then stitches, these are all, in other words, they call it as res ipsa loquitur, or so palpable. And this palpable, exceedingly suspicious actions which could not have happened at all, that will be criminal negligence, where there could be an error, like what Satvik was saying. Every error does not become a criminal negligence at all. They must be so egregious. So therefore, that is one of degree. It is subjective in some sense. So, and that's why there was one judgment which said, before the police takes a FIR for criminal negligence, there needs to be a body of opinion of doctors, or there must be some board which must say it is so serious. There must be an inquiry. There must be some investigation before a criminal case is registered. That is what was stated. They were trying to dilute it later. Don't make it like that as a point of law, but then let there be a good practice that you don't merely register a case on this. You will have to see that there is some appropriate investigation is done by somebody other than the immediate person who is doing it. So that these are some general observations of what I said, but excellent presentation from Dr. Satvik, and must congratulate. And he brings a lot of clarity to many of the things which you're probably looking for an answer. So if there is anything generally of what you face, there have been some questions. I was responding to some of them, but not to all, because I started responding only towards the end, because Satvik was carrying important things. I didn't want him to get distracted. Therefore, I was giving something in the boxes. But if there is something generally from medical negligence point of view,
there was one question whether
there is one thing. I'll close this with this. See, there is one thing which in another talk I had just participated. I was a listener, and I found the scholarly presentation which he made still suffered for a small deficit of not knowing a change of law which had come about, where he was referring to Bolam principle as the governing principle. It is not any longer the governing principle. The country that started in England, Bolam in 1957 judgment, where the standard medical care was test. So the outcome is not really the point for negligence. That a person walks into the hospital, that person is operated upon, the body is brought back from the hospital. I walked, this man got back dead. So therefore, there is negligence. It doesn't work like that. So if was the standard medical practice, because there are elements of risk which are there in the hospital, in the surgical procedure itself, that somebody was explaining. If it is properly explained, that's fine. But there, what had happened, the standard medical practice has been bunked now in UK, when they said that it's not sufficient at all. You need a disclosure of risk which is significant, and that must be voluntary whether the patient asks for it or not. And they were illustrating that case in a particular situation of a diminutive woman who, this case was in Montgomery in 2015. The UK Supreme Court said, where there is a person who was who had a natural per vagina delivery, and the child had dystocia, and the child was born with a defect because of that. And the patient sued the doctor by saying, I was short in stature, I was a diabetic already, and the risk involved for a delivery to be normal was and could be high. Why was not elective cesarean done? Was the question which was taken. And the point was, standard practice and the usual practice is to deliver per vagina. So therefore, Caesar was not adopted. It's not very material, was the defense which was taken by the doctor. But the court said, now, is there a risk or not? Is that risk significant or not? For a short-statured woman who had an issue of medical condition, is it not at least necessary for you to tell the person there could be a problem? You can deliver a child easily. So it could be a natural delivery. In fact, in that case, the mother had asked, will I deliver all right? Will there be everything all right? Then the doctor says, yes, everything will be all right. there the doctor needed to say, yeah, everything should normally be all right. But there are also instances where such kind of physical conditions of persons and some medical condition or what you have can result in some problem. That disclosure of risk, if it was not there, then it is medical negligence. This was Montgomery, where they have said standard medical practice, bolum, we are discarding bolum. That's what they say. We are still carrying bolum for a long time. And now in one case where a premature born child, where they did not probably look for whether there was a retinopathy of maturity. Probably there is a medical condition where premature born, you need to immediately call an eye surgeon to see whether things were all right. The child lost its vision. And they said, the court said, the court said, we are not really examining the issue whether there was a risk involved there for premature delivery for a child to have a retinopathy. But that was exactly the condition which UK was saying. But then they said, no, that law has changed. While they made the hospital and the doctor liable, the law has changed. Montgomery is now substituted bolum, they said. Here, bolum principle would have been sufficient to make the doctor liable there. A standard medical procedure would have probably resulted in getting the child examined where the child was born prematurely for eye defect or not. So therefore, it's just that we need to know in medical negligence, something new has happened. So therefore, I would suggest to every one of the doctors here, it is everyone's experience, that person who takes a consent form merely marks there, sir, put your signature. And they have applied it to me. In fact, I was asking the sister, what I need, do you know what you're asking me to sign? I don't know, sir. The doctor wanted me to secure. So the nurse does not know. She is the one who, in fact, is desirable. An anesthetist comes and takes the consent form and then explains what is there. And therefore, that form, a greater care must be there to inform whatever little risk which is significant. It's not a percentage of incidence that matters, but is it significant? That is a question which Montgomery, the Supreme Court, was asking, and which principle has now been adopted in Agrasen Hospital in 2019 by Justice Malhotra, Indu Malhotra. It's significant for us to know that there is a greater need for disclosure of risk voluntarily without the patient asking. That is an increased content of the law of medical negligence now to know. Because we are talking generally about medical negligence, that is one additional point. He had brought out such brilliant presentation. Therefore, if as an expert in this field of law and justice, to also understand medicine, I have just this additional point to make. So thank you very much. More questions from you? If there is anything, I will have. Otherwise, Satvik is there, who is better equipped.
No, not at all.
And one more chat box question, whether anyway nurses were held responsible for negligence. Yes.
That's right. That's right. By vicarious liability takes it to somebody else.
Like
so, but then therefore they get completely covered. Nurse, will she be liable? No. There is a hospital where she is working. Criminal liability cannot be fastened to anyone else. But then civil liability will be always, whereas vicarious liability exists, vicarious liability will make all of them jointly liable. But anyone knows, if there is an award against a nurse and a hospital, will I proceed against the nurse or the hospital? So that's the obvious answer.
Lordship, we get into the problem when a sponge is kept inside the abdomen during operation. The question comes whether the surgeon is responsible, nurse is responsible, like that. So
all of them become responsible.
Actually, in Kerala State Consumer Forum, it has held only the nurse and the hospital, and the Kerala State Consumer Forum has omitted the surgeon because it has
is perfect, because you have the vicarious liability principle
hospital, that's right.
Because the nurse would have been an employee of the hospital, and doctors, the surgeon would be a consultant surgeon.
Yes, that's what exactly happened. So for doctors, I want to say the surgeon is a consulting surgeon, and this is the first time even I have also seen the nurse and the hospital is held responsible, because routinely they used to ask when the instrument count is missing, sponge count is missing, because the court has clearly mentioned it is the duty of the nurse to check the instrument count and the sponge count. But again, it differs from the perception. So we have to be careful on that. Yeah. So Dr. Satvik, whether anybody, doctor can read LLB now, because they say it is available only in Maharashtra.
No, it's again something which I saw I had answered. The Bar Council
Justice
rules
Kannan has answered.
They prohibit any other professional. For instance, a chartered accountant, if he is there, can he be a practitioner of law? Can he do law? Unless he takes permission from the institute, he can't study law. Studying law, can study. Can he practice law? He can't. Unless he gives a letter of resignation with the Chartered Accountants Institute, he can't practice law here. So therefore, they are mutually exclusive. The same way, probably, as a lawyer, can he be a chartered accountant and also be practicing? The moment he says he opts to be a chartered accountant there, then his right to practice law will be withdrawn. So
I'm asking
these are all professional institutes which want to be very zealous about protecting the people and giving 100% devotion to that.
Lordship, whether they can study, that's the question, not practicing. Whether they can
study again, study comes like this. Whether it is possible, there is now a practical course which the Bar Council rules mandate. And of course, there are some Venkateswara University, some universities in Bangalore, they simply take anyone's certificate. He has been an intern somewhere. He has done so many hours. These are all now practical things. They are to be there, and practical classes must be attended in full-time course only. Part-time, there is no practical classes. Only in 3-year or 5-year course, you have practicals also. That practical can be there only in a full-time course that any other institute will not allow unless you do it on the slide. And when you are registering, I know of a chartered accountant who did law. Normally, he could not have pursued law unless he had informed. But without information, he was also getting from some university here in Andhra Pradesh and Venkateswara University that he attended all practical classes. Practical classes he couldn't have done. The Chartered Accountant Institute will take immediate disciplinary action that you had not taken our permission to do it. Law would have been the point. So therefore, it is not possible strictly, but then it is still done, that we know.
Bala, you have your hand up. You wanted to say something.
Yeah, Dr. Satvik, that was an excellent presentation. You started off well with the road to hell. So that was a practical statement. So my question to both of you, Satvik and Mr. Justice Kannan, sir, see, you described the first case scenario as aneurysm. Now, aneurysm, is it an error or is it a complication of the surgical procedures? Let me apply to my branch. I'm a cardiologist. So when a patient comes to me for an acute heart attack where there's an occlusion and is about to die, the mortality is about 90% in a major occlusion. So if I don't do an angioplasty, he is going to die. And if I do, there is a chance that the thrombus may rupture or dissection. Either way, there may be a complication. The patient may die. So in that case, from informed consent to informed request. See, some people are saying that doctors are going to start off from informed consent to informed risk. So previously it was a participative model. Now, participative model, previously it was a patriarchal model. Now the patients are supposed to take decisions. So I will tell the patient, okay, this is a scenario. You tell me, should I operate? Should I do an angioplasty or not? So I leave the option to you. So you take the decision whether I should do an angioplasty or not, number one. Number two, if you say that I should do an angioplasty, so under no circumstances, you must drag me to the court. So that is a precondition I like to make. Is it tenable in the law? Over to you. Thank you.
So the first point about whether, so the point of informed consent is that exactly what you said, is to, that is how the courts view informed consent, is that you as a doctor have a responsibility to inform, to give the patient that information which they can use to make a decision, to make a reasonably informed decision. So that is your job. You are supposed to give that patient that information. Now, if you have not given that patient that information, then how can that patient decide? So that is what the judges see. That is what the law sees, that you should have given that information so that a patient is able to make that decision. So now if you have informed the patient about this cardiac procedure and told them what are the risks, and that patient is willing for that surgery, then you are not liable for the damages that can happen. But again, this point that, make a blanket statement. Some hospitals actually do this. They take in their informed consent, they take a thing that says that if any complication happens, they are not responsible. That would not be valid. That would not be valid in a court of law. Now, the court, you cannot make such blanket statements. The court is going to see, now there is a law, but why are judges there? The point is the application of that law for that particular case. Now, just because there's a law doesn't mean that, every case no one can go to the court. The point why they go to the court is to see if that law is applicable to this case. How is it applicable? What are the practical points for that applicability? So if you take a consent saying that, no, if this complication happens, that I cannot be dragged to court. No, it will not stand. That document, that extra document you're getting signed that you are not allowed to take me to court, that will not stand. Now, if you have explained, taken a good informed consent, explained them to the risks, they can take you to court. There's nothing stopping them from taking you to court. You cannot have anything documented. No matter if you list 100 complications, you cannot say, no, I've listed every single thing. I have given a 1 hour video conference. You have recorded it, everything. Still, they can go to court. They can go to court. But the point is, the judge, if you have taken a good informed consent, you have informed all of these things, the judge will give it in your favor. So in court, you will have a defense. The judge will give it in your favor. But you cannot say that the patient is not allowed to take me to court, even if they are wrong. Even if they are 100% wrong, you have informed them the right thing and think you cannot take any signature, or it is not going to be valid to say that this person is not allowed to take me to court. Only the court has the right to decide of, can this, is it right? Who is in the right or wrong? But you cannot say, no, I've got it written, this person is wrong, and I can't be taken. That valid. So there are also consents that we have seen a lot of hospitals take. One thing is they do this. They list 100 complications, anything possible, and think, is that right? That is also not right, first of all. So in my many judgments, the judges have criticized such consent forms, which take such thing. There are many hospitals which take blanket consent, which just state that this surgery is an extremely dangerous surgery. There is a risk to life. So if anything happens, or if there's a risk to life, then I am not responsible. Again, not valid. You cannot take such consents. It has to be specific to the procedure. You need to give the information to the patient so that they can make an informed decision. And even then, they are allowed to go to court, and the court will decide. So you can't take something. There's nothing that will prevent a patient from going to court.
I'll add, Satvik, there is at the National Commission, Kantikar is your colleague, is a doctor. And as a doctor, he has said this pro forma consent forms where there are ticks marked with umpteen details given. It shows it's already prefixed and you are ticking something. If this constitutes unfair trade practice and awarded 10 lakh compensation against the hospital. So we probably use pro forma, but then it's essential to the particular patient. It has to be particularly stated. You can't type
to the particular procedure, right?
And that is found by the National Commission. And the adjudicating member was a doctor by profession, Dr. Kantikar, who continues there in the board, in the bench.
So the case that Justice is speaking about, the
Yeah.
case that Justice is speaking about is exactly that. A hospital which has listed a lot of complications, not specific to the procedure, listed a lot of complications, and then that a problem has occurred. And like Justice said, that is not valid. You cannot just list down, or else what we would do is you would list down any possible complication and use it for all surgery. That would not be valid.
Dr. Porwal, you have your hand up. You wanted to say something? Ronak?
I wanted to ask one question. I recently did my PGDMLE. While reading through that, I had a doubt. Say the patient is having a advanced directive with them, and patient is met into an accident, and the patient is a Jehovah Witness case. And doctor is aware that the patient is a Jehovah Witness case, and patient requires transfusion. So patient will survive only if transfusion is given. Say his hemoglobin is 5 or 4 in that level. So should the doctor go ahead to save the patient by transfusion or obey the advance directive given by the patient?
Yeah, there is an answer there. If I may answer, Satvik, is that
Yeah, sure, sir.
Yeah, see, now this is a case law from Kerala, which has come, where a claim for compensation was made at the instance of a patient and a representative for administering blood transfusion to Jehovah's Witnesses. Jehovah's Witness is where the blood is so pure for oneself, which is assigned by the religious belief. Nobody else's blood can give. He's a sinner. He has to shed his blood. He has to acquire his blood. So that is the idea. So therefore, a doctor cannot breach, for it will amount to, without a consent. We are not talking about informed consent. Without consent, if a doctor does something, it amounts to battery. It is an offense, and it's a criminal offense. So there is no question. A doctor cannot do. But can you do anything against advance directives? Now, this is done in Common Cause versus Union of India, where a 5-member bench was considering issues relating to advance directive. In the context of euthanasia, they approved a passive euthanasia. Now, while they were talking about advance directive, how it should be done, there is another paragraph which says, where there is no advance directive, what is to be done? Whatever is required to be done under advance directive is required to be done under where there is no advance directive given, which is another way of saying that if a person says, don't treat me, don't withdraw, I don't give any consent for administration of anything. If therefore I have advance directive or no advance directive, if the doctor wants to do, he has to do a procedure what the judgment prescribes. It is to be now first approved by a primary medical committee, which will be of the hospital with one expert, the doctor, treating doctor, and one doctor of a domain expert. And then the secondary consent, which should be there by the DMO or this authorized person, and 2 persons with 5 years of experience. Then only these things must. Therefore, if a Jehovah's Witness says that I won't want to be treated, but the doctor willy-nilly believes that he has to save him and then do something by himself, if he's trying to do, he'll be committing criminal offense. And if he still believes that something has to be done, he has to secure this consent. And I believe no such board at the primary level or the secondary level will allow for enforcement of such a forced transfusion to a person to save the person.
There will be no times when patient is bleeding to death to form committees and all. So I'll just add a little small twist to what if you didn't know that patient was a Jehovah's Witness and patient was brought to the ER and with polytrauma, you gave the transfusion, and then afterwards patient was unconscious that time, or and afterwards you find out that actually patient is a Jehovah's Witness and would not have consented for, or later patient says that why did you give me blood? How does that pan out?
That won't be an issue at all because the doctor has
no, we'll
not
have
known.
the experts to. We'll leave the experts to answer, Doctor, on it. Yeah. Kannan sir.
You are asking for the decision. I can tell you this case is, I can give you the citation. It is Mallet versus Schulman in a foreign country. And in Indian case, which you are asking, I can give that also. That is another Jehovah's Witness case was, yeah, I have this citation there. But isn't it too technical for you to know that? I can give you the citation.
No, I'm just asking, would you be criminal? I mean, it can happen to any one of us tomorrow. There's a patient in the ER, you don't know that patient is Jehovah's Witness. Polytrauma, head injury, patient's unconscious.
No question. Then in which case he can't complain at all, because the doctor's duty, it will be unethical. You will test it this way. A doctor, by the ethical considerations of what is there, the duty is to treat. You have the Hippocrates oath, and your duty is now restated there in the medical ethical guidelines. So you are bound to treat that person. And if you're treating and the person later says, no, I am a Jehovah's Witness, I wouldn't have been given. There's no question. The doctor has a complete answer. He has done what he is duty bound to do. If he had not done, he would be found guilty of negligence.
Thank you. Ravi, you have your hand up. You wanted to say something? Ravi Shankar?
Yeah, sorry. Can you hear me?
Yeah.
Yeah, sorry. So my question is actually slightly different. So I do a
Yes.
lot of clinical trials, and in our consent forms, many countries require us to put the proportion of the adverse events, meaning the percentage of people who have experienced it in the past. Is there any such requirement for a clinical informed consent? So I just heard everybody saying that you cannot put a laundry list of everything that any potential, any possible, side effect or adverse event. But do you need to put, I mean, how do you decide? Is there a threshold that you need to put in things that happen more than 10% of the time or 15% of the time? What
You are
determines
speaking from,
the?
are you from UK?
No, I'm from the the US.
Okay, because in UK they have really raised the question in Montgomery. Do you need to assess the percentage of risk? Do you need to see that? And they said it is not about percentage at all. They've said it's not percentage. Is it significant? That's what they say. Would you have changed at all? In the case in Montgomery, when the patient is asking, will I be able to save, will I have a sure and safe delivery doctor? The doctor, you'll be all right. That was an occasion where he was bound to say, because it was significant for a patient, even that small doubt, even if you are talking about 1% risk or something, that 1% is not the percentage that matters, but it is significant for the person. That's what it means. So, and all several things, it has to be realistic. And see, when both Satvik and I were trying to point out to the pro forma consent forms and how it is ticked, and where Dr. Kantikar, MBBS trained doctor sitting in the National Commission, they found it was unfair trade practice. He was saying, now you're not informing anything to them. You're merely saying that it's a grave risk, or you're bound to have so many risks. Why anyone knows? One of the famous hospitals in Chennai had a tonsillitis surgery by one of the most eminent doctors. I'm not naming. And they did not, the Consumer Commission here threw out that case, because they said, now if any surgical procedure is risky. And there was a xylocaine issue of the test dose probably didn't reveal anything, but then it worked like that. It caused a grievous, it ultimately caused death. So therefore, need to be realistic that you have really addressed issues which are relevant, and informed consent of how Satvik explained some time back. You need to inform what is there about that. What is it that you are really exposing yourself to? That kind of a thing must be realistic, and that is what is necessary.
So
But I think we run into the same problem of meaningful versus measurable, right? So death is a meaningful consequence, and it could happen even from from a tonsillectomy or an appendectomy. But is it meaningful to put it in the consent form for tonsillectomy or
in
appendectomy?
terms of, to add to just, I think Justice Kannan has already explained it, but to kind of apply that same what he has told to from the medical perspective of when you're taking consents with different procedures. Now the problem is that every procedure is different, right? So the question comes as to what do we say about each procedure. So the landmark judgment for that in India is the Samira Kohli case, which talks exactly about what should be there in the consent form. So what it says is that the information that you need to give the patient is such that they can make an informed decision, not such that they know every single thing about that procedure. So again, now any procedure can cause any rare complication. Now there might be a complication which has an incidence of 0.5%. Can that happen? Yes, maybe in 1 in 1,000 cases that has happened. Does that mean that in every 1,000 case you are supposed to have listed every complication? So then it gets to, the unpractical side of it. It becomes like, okay, there's one paper here which says that it has reported this complication. So do we list now? Do we have to include all of these things now? It is a possibility. Maybe your patient was one among those 1,000 who had that. So do we have to list everything? No. So actually the Samira Kohli judgment gives a point that it needs to be reasonable, practical, and enough for the patient to make a reasonable, informed decision. So what they say is, So what we recommend as a practical guide when you're doing different procedures is inform them about the common complications. What are the most common complications? Inform them about certain rarer but more dire complications. Okay. So now death for an appendix, for a small procedure. Now, even a lipoma excision like I was giving can happen. You never know what the reaction is to that. So inform them about common complications, a few rarer, more dire complications. So that is what you need to inform them about. So what we say is, what I would recommend is at least 3 or 4 of the most common complications. That is what we would know. Okay, this surgery, what are the most likely complications? You don't have to sit and get into, okay, this much percentage, all of that, but these are the complications. And some more serious complications also, if that's a possibility for that surgery, even though that's rare. 100% serious complications would be less rare, but you need to even explain that so that the patient can understand that there is a certain, it is a serious surgery. There is a chance of, a serious thing. But that doesn't mean that every patient who comes in with a lipoma excision, because 1 in 10,000 have had some reaction, that you say that, oh, you know what, this is a life-threatening surgery. That's not what you need to give a realistic explanation. So even if, so that was actually a point that someone had raised when the first question, when we started the discussion of the first slide is, as long as the complication you have informed them, you're safe. Okay, so then, but that is not true. That is not true. Even if there is a complication that occurs which you have not informed them, doesn't mean you are medically negligent. Like now, say a procedure, you have explained the common complications of it, a few dire complications. Now a rare complication has occurred, a really rare complication, right? You have not informed them in the consent form. So now are you liable because you have not informed them of this risk, right? No, even then you are not liable. You cannot, even the law understands that you cannot sit and give everything. In fact, it is wrong if you sit and list 100 complications, right? So even if it occurs, that just because a complication which you have not listed occurs, doesn't mean you're directly medically negligent. They will still assess. If that complication has occurred, the judge is still going to assess, is this reasonable? Is reasonable care taken? Has something been done to prevent it? Is it something because of, the doctor being completely negligent? Has he been very rash in his actions and that has caused this rare complication? If he has taken all the due cares and unfortunately some rare complication has occurred, then that's not negligence, right? So you don't have to worry about every small complication that might have occurred, but you need to give a reasonable picture to the patient.
Dr. Ravishankar, just because you are from United States, you should be more worried than the Indian doctors, because the United States laws are very strict. Because I want to inform you, you have to follow informed consent. But I request not only you, but all the delegates present here, please read the Supreme Court judgment about Prabha Manchanta versus Samira Kohli, because it is an extensive judgment. You have to know what is the informed consent and what is the real consent. Now the Supreme Court, because Dr. Satvik explained that, but the Supreme Court has given the background. It says, if you started saying perioperative death is a complication, it is naturally, as you said, whether it is tonsillectomy or appendectomy, perioperative death can occur not by surgery, but by anesthesia, it can happen. But the court has warned in India, because it is Indian court, Honorable Supreme Court warned, in India, the literacy rate is not uniform throughout the country. So if you explain more risks, people may seek alternate modes of treatment, because the judge justifies his stand. He is not saying that. That is the reason why we have to appreciate, we have to read it in their own words, because they are non-medical people. But even then they say, if you explain everything without any bias, just like if you impart your medical knowledge, then they will go for an alternate mode of treatment and they may refuse even the justified treatment. And that is the reason they say, even if I remember correct, in paragraph 32, they have mentioned the 10%. It is 10% because they say, if you need not explain all the complications. So in India, with that Supreme Court judgment, we can argue against informed consent because they want a UK terminology.
Dr. Meenakshi Sundaram, I'm cutting in here because that's not getting to be a correct statement of what you're saying, and therefore, because Samira Kohli is not a wrong judgment. It makes a difference between informed consent and consent.
Really?
And there, Justice Ravindran, that's a 2007 case where Justice Ravindran was saying Canterbury principle of USA, where informed consent requires everything to be done, need not be followed in India, because medical paternalism exists in India. People see doctors as demigods. Don't take away that element of trust. We will therefore be guided by Bolam. Bolam provides for standard medical practice. Here it's a reproductive choice where you're removing an ovary. Therefore, even though the patient was there in a comatose state, you had explained to the mother of the patient, that would be sufficient. Now, Bolam, of what Samira Kohli was relying on, is not the law now in UK. The medical paternalism of what UK was prepared to discard and allow for standard medical practice is not the law in UK. Bolam has been discarded in Montgomery. Montgomery has become the law in Aggression in 2019. So therefore, please take Samira Kohli with a pinch of salt now. That the ultimate decision there was correct, but the statement of law as Canterbury principle will not apply is not the law. Canterbury is what has now been brought through Montgomery. Montgomery is what is brought in this. Yes.
That's right. As Justice points out, that the statement is right, but what I want to convey, we need not frighten the patient. And if suppose the patient sues us in the court of law that this was not explained to me, then we can take a cover, or the defense argument will be, we need not explain everything, that is 100%. But again, in that case, the judgment will depend upon the perception of the sitting judge.
So there are a lot of questions there. We may not be able to take all the questions, but if any one of the panel want to take any particular question, we can go ahead. Meanwhile, Radhakrishna, we're really close to 2 hours. You want to add something now? I request the Satvik and the moderators just go through the question in the chat box and see if anything pops out which they would like to actually take on, because I don't think we'll be able to take all the questions that are there. Yeah, go ahead,
Yes.
Radhakrishna.
Vidya, I think it's been a... Yes, sir. Meenakshi Sundaram,
because the question I have seen, Dr. Meenakshi Sundaram to
Sir,
answer.
just please go ahead. Please go ahead. I mean, please look at all the questions, sir. Meanwhile, we'll come back to you. Please, I request all 3 of you to go through the question box. And I mean, every question may not be answerable, but nevertheless, whatever seems important, please go ahead. Yes, Radhakrishna.
Yeah, it's I mean, real wonderful session, I should say, and more than 150 attendees is a huge number. And to my surprise, Satvik happens to be a chocolate hero type person. I was expecting somebody very harsh, rude, using some legal language, and he's an orthopedic surgeon at that. And I think he's presented the whole thing so very well in very perfect terms, and not hurting anybody, not ruffling feathers, not finding fault, and no any legal language. And of course, Dr. Kannan is, Justice Kannan is well known to marvelous medicine, and he's been very, very considerate to. Actually, there's no blame game anywhere, and it's been wonderful. And I'm just expecting Satvik to put up his telephone number, and thing which he did, and I'm sure we'll be flooded with calls left, right, center. But I don't know whether they'll pay you anything for that. Do you practice law, or you have a battery of lawyers practicing? Because there's some legal issue there that you can't be an orthopedic surgeon and practicing law. Do you represent anybody in the court of law?
No. So I cannot represent anybody in a court of law. So I don't practice law at all. So basically, what I do is help lawyers and help patients. So basically, so we have people like Justice Kannan
You
who have
help
been.
lawyers to help doctors.
We help both sides basically deal with medical legal issues. So to understand both sides. So the problem is, see, now we don't see it enough, because now with Justice Kannan, he's handled so many medical legal issues. He's read so much about of medical law, all of it, that he understands both sides, right? But if in general you're going to a lawyer, he would not be knowing all of these points. There's so much of law they will be reading. So no matter what doctors explain, now we might say whatever it is, but if someone who doesn't have this medical experience or this experience of dealing with medical law, they are going to be perplexed. So what we found is there were so many situations where lawyers were not doing the right representation of what the doctor's really saying. So not with any wrong intent, but just because they couldn't comprehend it. So that there is a big gap between lawyers and doctors. So my aim, our firm's aim, is to basically bridge that gap, is to help uh, doctors, guide them on what the legal principles are. So we will take the services of a lawyer. So I'm not a lawyer. So we have lawyers who we are associated with. So we take the services of the lawyer associates to represent in court, but to basically help the doctors with that, and even help the lawyers with a lot of medical literature. So when in court, anything that you need to argue has to be based on evidence. That has to be based on literature. So we help them with all of those points. So we are basically a bridge. So I'm not a lawyer.
Wonderful. I mean, that's very nice of you. I have two
I see,
points.
I
Yes,
see
sir.
a question by Doctor, not a question, it's an observation, but which is relevant, which is now topical. It's about the violence against doctors present all around. And we all know what had happened in Calcutta, how the nation is going through the pangs of all anxieties and worries. It is now not a new call. It has been there under serious consideration. There needs to be a law, is what probably Delhi had a team of doctors giving out. And the Thiruvananthapuram declaration, long time back, they had already given something on those lines. But what we did during COVID, where the doctors were really seen as vulnerable to all kind of vague attacks and things, the government, under the Pandemic Act, it's a British legislation, they gave a notification that if any doctor is attacked or in any way injured or any way insulted, it will constitute an offense, and a punishment up to 2 years was provided there through a notification. We don't have an exclusive legislation for a non-pandemic situation, which is a dangerous thing. The doctors that needs to see, these are all things which nobody is going to be immediately, if he's coming and breaking the doors of a hospital, he is not looking whether there is a section under what act. But then there is a fear that I can't do, it will be a criminal offense, I'll be taken and I can be booked under something is the necessary thing. So this is something which probably your association at a national level must put their heads together. It's already now, it's some bad situation makes some good law. The good situation make bad law. Both ways it happens. Now, this macabre incident of what has happened in Calcutta is now bringing a lot of people to think that doctors must have safety in the places of work. So it's not merely sexual violence we are talking about. The facilities of what they have, the physical, even mental trauma, because Satvik took that aspect relating to defamation as well, where somebody could be foul-mouthing doctors. Even that should be treated as something very serious, that if somebody is seen to be doing something without adequate reason, and merely because some person died after a treatment was administered. Now, to foul mouth, it could be wrong. So therefore, to make them, to cover them through an exclusive legislation is probably truly an important piece of legislation which must come. You must lobby for it and then secure it. Now is the time.
Yeah, what surprises is there's a bunch of doctors, I mean, a bunch of lawyers supporting the criminal side of the thing and arguing. So why should that happen? I think 100% of the lawyers should be in favor of the person who died and all. But why is that? They try to bring out all
we'll
the
call
legal
names
points.
now. Now that you're saying that, I'll call name. Why is Kapil Sibal arguing is what he's probably asking. I'm
How
telling
can he
you.
do that?
See, how it is like this. Even the worst of enemies, if there was a Godse who is pumping bullets directly before the Mahatma, whom we all regard like that, he had a trial which was running. Kasab, who was spilling bullets and getting captured everywhere. The government spent 30 crores for that litigation, which took 1 year. And when it went on an appeal, the Supreme Court appointed a senior counsel, Raju Ramachandran, to conduct the case and then gave 15 lakhs as his fee. And Raju Ramachandran gave it to the victim's family. So to give a defense lawyer to any person accused is the ethical thing to do. So therefore, it could be otherwise a banana republic where we all think this is wrong. We hang them. It happens in some countries. The barbarous it is. So therefore, give the right. There is a rule of law. Make a person make defense possible. Don't worry about it. I don't think you should. Why should then you are getting to be judgmental? Which is that case where somebody must appear or not? That is subjective again.
I have two more points to make. One is just like the Me Too and the HEMA committee, if somebody comes up and says 20 years ago you did this, and doctors also fall into that category. Somebody can pick up something happened 20 years ago and then go to court. And are we immune? Is there any time period that we can only the last 3 years or last 10 years?
I'll now tell you, now that you're asking that question, in Kalakshetra, where I was heading a committee for a sexual harassment issue, and we have given a report, and it was there in paper, probably, I don't know whether you followed. There, a former professor, assistant professor, who is not any longer at that institute, is accused of rape. The incident is being narrated by two women of what had happened 20 years back. There is a criminal case which is lodged, that prosecution is on. He was stopped midway at an airport in Germany and brought back to India, knowing that there was a complaint which was lodged. So there is no time period at all for criminal offense. There is nothing that can impair or stop.
And one final point. Yeah, Vidya.
No, go ahead. Navya wanted to say something.
One final thing that intrigues me again is but somebody loses a case in a small court, goes to the next court, and the next court says the small court is wrong. Then he'll go to the next court, the next court. How can lawyers be wrong? Will you accept it in medical profession? Because, people operating in primary health centers and taluk hospitals can make mistakes. People only tertiary care can make mistakes. Because why don't you accept that? How lawyers can give wrong judgments all along?
See, this is a problem issue we keep seeing. There are a lot of people who say, how is it that there is a case which is decided by a judge, which is modified by another court, which is modified by another? If the Supreme Court has a super Supreme Court, half the judgments of the Supreme Court will also be reversed. You need to know that, because judgment making is like that. Judgment making comes through several factors, how you piece together. That's why you have a funny expression in the Evidence Act. What is a thing to be proved? There is a question, section 3. Answer. Anything is said to be proved if a judge believes it to be true. Suddenly you bring a belief aspect there. So therefore, what is belief now? How do you, the issues of logic, we understand how so many factors, 1, 2, 3, 10 factors, they must form themselves and then make them. How do I understand that? How do we have fight in the house between spouses if they're aligned to run a family? That there are difference in perspectives, and that's all it is about judges. So therefore, if such intimate persons could be fighting, greater reasons for judges to be taking different views.
Navya wants to say something.
Yeah.
Navya.
Yeah. Go ahead, Navya.
Navya?
I think she switched on, but actually I should.
Yeah, there she is. Yes.
You're muted, Navya. You're muted.
Please unmute. Yeah. We can't hear you.
You're good to go now. It's unmuted. Go.
Yeah. It is muted again.
You're muted again. Yeah. Now you're fine. Yeah.
Yeah.
If only you talk, we'll be able to hear. You choose to talk and unmute yourself.
Right.
Okay. I think she's having some technical,
Madam,
technical issues.
Audio for her.
Yes,
connecting to audio.
I thank Justice for the open admission, because I have friends in the justice circle, but this is the first judge I am saying who honestly accepts this is the hierarchy. It varies from the order is modified, because even I have written it in the poetry also. When the lower court punishes one, the high court acquits. But I thank Lordship for your generous admission that it is regarding perception, because routinely everyone asks, when two judges sitting in the same room, listening to the same witness, but they are giving a split verdict. But a doctor sitting in one place does mistake and treated by another doctor 50 kilometers away, it is held guilty. But there is a fixed textbook for law. The judges are sitting in the same court hall, listening to the same witness, but a split verdict happens. Anyway, that is a system. But now only we started questioning, we are asking, we are discussing. So in due course, it will change. Then I want to answer Dr. Radhakrishnan why a senior counsel is appearing for the accused in Arjikar case. This is just like a doctor treating even his enemy. Whenever somebody is injured, whether he is an enemy, we will treat somebody.
We can't accept it.
Somebody is appearing because it is their ethics. They let them appear. But the question one person asked, a nurse has taken the baby, sick baby, to the ICU. She started running without informing the mother or the father. Then the father questioned how you can run without informing me. Whether it is negligence, a person has asked. It is not a negligence because it is emergency, gives you the cover. So it is not a problem. Another person has asked whether video consent is valid. Video consent is also valid. But so far things stand, the written consent, we feel safe because it is the old habits die hard. It is there. In due course, this video consent will also come. But in the video consenting, you have to inform the party before recording that you are going to record. Even if it is a voice record or a video record, there should be a mutual consent that you are going to record, because we don't know what is the rule at that time in BNS. So that is the one point. So
many times the patients record without your notice, without your permission.
Yes, sir.
Is that legal?
Yeah, justice has to answer, because even I want to say, see, there are so many CCTV recordings, there are so secret recordings, but I have read the Evidence Act. First of all, I thought recording a phone conversation, recording a video conversation without our consent is illegal. But it is not like that. That's what I want to convey. I even discussed with the judges. They say the circumstantial evidence gives the weightage. If suppose somebody records, even so many diverse cases were decided by the telephone recordings. I thought BSNL prohibits recording even before the landline. So the justice has to throw light on that. Absolutely, I have discussed with the judges, but they are not asking why you have recorded that. See, they are interrogating the people who were victimized by that recording. They are not asking the person who have recorded the video whether you have a valid consent for recording. But only one exception was there in Madurai.
Yeah, it is, see, it's not as hazy a law now. It's now rooted in strong legal principles. For a long time, privacy was not a right. It was something which was enjoyed, and it's more out of courtesy. It's more than civilities. It had to do with civilities. Now it has become a fundamental right in Justice Puttaswamy's judgment in 2017, where 5 judges held together in a constitutional bench that it is a fundamental right. I have a right to privacy. I may choose not to disclose, and you can't compel. No, this was the ramification of this privacy came to be spilled in several areas. Whether somebody can record a phone conversation, can in Zoom meeting or here when we have a meeting like this, is recording permitted or not? You saw probably at the time when you're logging in, it shows now this is being recorded. Is it okay? If it's not okay, you are out of it. So therefore, there is in every system, it is inbuilt now that you have concurrence. Now, if you are doing something without that, now it's a 2017 legislation now, which was driven through judicial opinions. if a doctor treating a man, is he bound to inform his wife that your husband has this? Now, it's a private issue. Normally, there is a confidentiality between a doctor and a patient. But then, would a doctor require to tell a spouse? Now, there is a legislation which talks about when there are exceptions which can be drawn to confidentiality, when there can be exception to this kind of when you can record and when you can't do. So therefore, if I can exercise and point out a recording is sought to be used somewhere, that user can be stopped and you can exclude. The Evidence Act itself, now that you say you have read the Evidence Act, there are some privileged communications, an attorney to a patient, a doctor to a patient, professional engagement. They are all privileged communications. A spouse, between two spouses, of what they exchange between. Matrimonial disclosures need not be compelled. No person, no spouse can. In fact, a spouse can be a witness for yet another person. Even if that person does not come, she can substitute or he can substitute her. So that is the level. All legislation, therefore, provide for privileged communications, protect privacy, and make exceptions for that where there is a larger good. So therefore, whether a person is bound to disclose that a person is mentally unsound or somebody doctor is treating, these are all cases which have come. A person treating a medically a person for psychiatric drugs for medical illness. Somebody comes and says, we are looking for a bride. Is that okay, doctor? And the doctor, the person be compelled to say of what he knows about the mental condition. These are all true issues which have come. So therefore, it's not without answers. It's all very clear when it is sought to be used, and it can be said it's privileged, it can't be used. This phone conversation cannot be taken because it is private and it could not have done. He did not have my concurrence. No court, even if it hears, can rely on that and pass any order. So that is the protection which is available. Privacy is now a fundamental right. It's not merely a right, it's fundamental.
So yes, sir.
Lordship, what Dr. Radhakrishnan wanted to know, if a person is entering your chamber, having a cordial discussion, so at that time you may bound to speak anything, because we are not guarded. At that time, if he records the conversation, whether it is legal or not.
It is not legal at all. It is not legal. No conversation can ever be, unless it is a public meeting where the consent is taken. It's in a room, a person comes, it's my room, you come into my room, I have no business. In fact, there was a judge in Madras High Court, S.N. Subramaniam, who had a camera in his room. He wanted to make it known to outside people, whatever I do, you'll be able to see. The issue was, some person who wants to come for a genuine reason, he wants it to be personal, to be telling only a judge. Should it be made known to the world? There was a point. So therefore, there were objections taken. He continues to have it is another thing, but it was a legitimate thing that you may think that you are open, but then there may be instances where a judge is bound to listen to something which is very private and confidential. It has happened. I've seen there are confidential information, matrimonial information, which a client cannot say. Therefore, you have in the Family Courts Act saying no, all cases relating to matrimony must be in camera. All sexual offenses must be in camera. In camera is a manner of excluding public. Otherwise, all proceedings in court are public. So therefore, that recording is wrong. Unless I have my concurrence, you can't record. So a litigant who comes to a judge's chamber can say, sir, please put off the camera. I want to say something. He has a right to do that. The judge has to defer to it.
Thanks. Because so many...
You're muted, Vidya.
Yeah, now Dr. Navya is muted. Because so many vigilance cases, they submit only the video recordings. So that is the reason.
Not possible, sir. The vigilance cases only, this telephone, whether a person is present or not could be stated. But it may lead to something. See, he may have contacted, after having committed a murder, he is telling the boss, Sir, I've done it. Then they're able to trace the call. It may lead to a recovery, lead to a person, but the call is the thing which he was relying on. He may not be able to do. Matters of national security are exceptions. It's provided there. If he is planning to kill, if he is planning to bomb, all that intentions on the ground of national security, there are exceptions provided in the Act. In the Telegraph Act, there is some exception there. Now, in the Cyber Crimes Act also, there are some exceptions. So that's why where a government, a state functionary may have a right. You and I may not have that right. A state will have for the sake of the nation and security.
But in the Evidence Act, they say that the original video instrument should be available. The computer which transfers
that's another thing.
Everything is there.
Primary evidence is secondary. You're talking about something else then.
But it is not mentioned whether it is legal or not. That is the reason.
No, it's not necessary because it's governed by some other principle. There are multiple principles. There are constitutional principles which need not be stated in an Evidence Act, which is a subsidiary enactment.
Thanks a lot, Chief.
Yeah. So I think we've had a really long and fruitful session, and it's very evident, like as Justice Kannan suggested, that we need a follow-up because there's so much more to cover. So in the coming months, we'll probably every 6 to 8 weeks, we'll try and include something related to medical legal, and maybe we'll have more time focused on each particular act or the law, which then maybe we'll have a discussion, and we may be able to finish it on time. But thank you everybody for your overwhelming response to today's program. Even at the end of 2 hours, we still have so many people logged in. We are sorry if we could not take everybody's questions, but the recordings will be available on YouTube subsequently. Satvik, somebody is asking for your email ID, so maybe you can just put it there in the chat box. And closing comments.
Shiva will have one last word.
Shiva, you wanted to say something? Was your hand up?
No. I was trying to say clap the hand, and I'm learning how to use this thing. But there's been a very interesting case here. In South Africa, the doctors, neurosurgeons and obstetricians are being sued left, right, and center. And so the insurance is really high. It's about R1 million, and you have to do 10 deliveries just to pay your insurance per month. So imagine just doing 10 confinements just to pay insurance. So the doctors here decided something, that they'll get a consent form to say, if you not going to litigate, then the fee will be this much, but you'll be exempt from this. But if you do not accept this, then you'll have to pay what my medical legal cost is, because that was this. It was ruled out of when the case went to court for somebody who signed and didn't pay that extra amount for medical legal case. They said you cannot prevent a negligent case or anything like that. And it was a very landmark judgment, because now we all have to just pay a huge amount of money. But I was just trying to say, fantastic session. I really enjoyed it.
Yeah, your closing comments, Satvik.
Yes, so it's been a great session. It's been a great session that I've really enjoyed. A lot to learn from everyone here, especially Justice Kannan and everyone else as well. A lot of good points that were raised throughout, even by Dr. Meenakshi, everyone. So enjoyed it. Happy that ma'am took this initiative, talked about this important thing. So glad that everyone learned something.
Your closing comments, Dr. Meenakshi Sundaram sir.
Yeah, it is a very good discussion. Justice, because really I'm overwhelmed. The justice remarks were excellent, and he was very open, and he could deliver some important messages to all the audience. So I really enjoyed, and it should continue, because the plethora of questions which are pouring in the chat box says people are worried about legal problems. So the take-home message I can say, regarding consumer laws, we have to be careful, but we need not be so worried, because so many doctors are ready to help. Now, so many judges are giving guidance for us. So I appeal to all the doctors assembled over here. We need not worry about consumer laws, because as a highly qualified people, we should also be a law-abiding citizen. So we will concentrate and need not worry. Thank you very much.
What I notice is if there is any one profession which is held in the highest esteem in a state of despondency and cynicism that exists everywhere about India, it is the doctors who stand out as exceptions. So therefore, the confidence is not lost, and it is in some way infectious. I must say, by and large, all forums and courts are protective to doctors. You must know, from 1950 to 1967, there had not been a single case of before the Supreme Court against doctors. And only from 1984, with the Consumer Protection Act, when it came, it opened a new, that was again necessary, that we were making people accountable. Politicians grew to be prosecuted only post that 1990. So therefore, we have seen everyone to be accountable. That's fair enough. That's a good thing which is happening. So let us not be worried about it. By and large, they are supportive, and therefore that ought not to worry us. To be careful about what we do, to take a sense of duty to how we, as persons, specially trained to care for the sick and the ailing, is such a noble duty. So therefore, that you should be interested and that you should all be keyed up to know what the law says to regulate it is essential, because ignorance of law is no excuse. And everyone is bound to, I don't need to know medicine, but you need to know law. That is the reason. And that, I suppose, is what gets to be the reason, the fulcral reason why we are discussing that. So wish you all the best. And I'll be able to join in at every time. In fact, I must tell you what others may not be knowing. Every week, Dr. Vidya sends an invite to me. I'm sure I'm in the mailing list. That's fine. But then she will again, directly from her, I will also receive. So that if I don't come on many occasions, they're probably a little too above me, and therefore, otherwise, I'm interested in knowing what the doctor community wants to know. After all, we deal with all types of persons, and doctors are such an important person in the society.
Thank you so much, sir. Thank you, everybody, once again. We'll meet again next week with another episode of Marvelous Medicine. And definitely within the next 2 months, we'll have another session on something to do with medicine and law.
Somebody says advanced directives. There are a lot of things which have come now from the previous judgment to the next one. And we need, I've heard in several meetings, I used to ask, have you seen any advanced directive? Not one I've heard so far. So I would like to know why it is happening and what we need to be doing.
So in fact, the first time Justice Kannan got associated with Marvelous Medicine was actually when the initial thing on the living bill came. And now, of course, things have more simplified, but I suppose we need a session on that, because when most of the audience of Marvelous Medicine is a little on the older side. So I think there'll be a lot of interest on advanced directives.
Yeah, you need to make a...
Madam, how to write a bill, we'll probably be talking about it.
We have to make an episode of the 200th episode.
Madam, now he has become a marvelous judge and above everyone. So involve justice every time.
So actually in next month on, I mean, if we were to have a session on 17th, that would be the 200th episode of Marvelous Medicine. And so because we thought after 4 years of meeting online, we should finally try and meet offline. So we are planning to have an in-person meeting on 20th of October, because weekday will be difficult. So 20th October is a Sunday, and we are hoping to get people, at least those who are living in and around Chennai, to come together. It's for want of a better word, celebrate this milestone, which would not have been possible without, I don't know, maybe 500, 600 faculty who have, constantly supported us, taken time off busy schedules. And we were just an informal group who were just meeting every Thursday during COVID for chatting, but they took each episode so seriously. They prepared as if they were presenting at the international conference, and they were so open to discussions. Anyone could ask any question and it would be answered. People have learned how to differ in a civil way rather than fight over differences. So we have so many things to be thankful about. So we look forward to many of you being there we'll get back to you with the nitty-gritties, venue, time, and program particularly. So thank you once again.